Some members are here in person, others are participating remotely, but all members will be treated equally. I ask members in the room to respect social distancing. If the capacity of the committee room is exceeded or other safety requirements are breached, I will immediately adjourn the committee. If there is a division in the House, the committee will adjourn for 5 minutes. Whiplash Injury Regulations 2021 and debate on one other instrument. The time limit is 1 hour. Lord Wolfson.
My Lords, I beg to move that the Grand Committee do consider the Whiplash Injury Regulations 2021 and the Civil Liability Act 2018 Financial Conduct Authority Whiplash Regulations 2021. These draft statutory instruments are key components of the government's whiplash reforms. They will simplify the process of settling whiplash claims. They will provide certainty to claimants as to how much their claim is worth. They will benefit society by enabling an average reduction in insurance premiums for ordinary motorists of around £35 per premium. And I would remind the Grand Committee that the Secondary Legislation Scrutiny Committee has drawn both of these important SIs to the attention of the House. The House has had a number of extensive debates on the merits of the government's policy which underpins these SIs during the passage of the Civil Liability Act 2018, which I'll refer to as the Act. And so with the limited time available to us today, my focus will be on the detail of these regulations rather than on rehearsing past policy debates. The measures in Part 1 of the Act change the process for making whiplash claims by defining what constitutes a whiplash injury, introduces a fixed tariff of damages for pain, suffering and loss of amenity, or PSLA, provides for an uplift to be applied to the tariff amount in exceptional circumstances, and bans the practice of seeking or offering to settle a whiplash claim without first seeking appropriate medical evidence. In addition, we are also increasing the small claims track limit in respect of road traffic accident related personal injury claims from £1,000 to £5,000. We've also previously committed to increasing the small claims limit for all other types of personal injury, including employers and public liability claims, to £2,000. However, the Lord Chancellor has confirmed today through a written ministerial statement, which I've repeated, that the government has listened to the views of members of this House and others and has decided both to limit this increase to £1,500 and to defer its implementation to April 2022. And I hope the committee will agree that is a sensible and pragmatic decision which will give stakeholders additional time to prepare. The Whiplash Injury Regulation set out a tariff for the amount of damages payable for PSLA for a whiplash injury or injuries of up to 2 years and any minor psychological injuries suffered at the same time. They allow the court to apply an uplift of up to 20% to the tariff amount in exceptional circumstances. And regarding the ban on pre-medical report offers to settle, they specify what constitutes appropriate medical evidence and the experts who may provide it. And that will differ depending on whether the injuries include a non-whiplash element. The purpose of the other statutory instrument is to give powers to the Financial Conduct Authority, the FCA, to enable it to monitor and enforce the ban on pre-medical offers to settle. Let me now provide a little more detail on each regulation. Starting with the tariff figures, they present a rising scale of fixed payments determined by injury duration, with damages reduced less at the top end to recognise more serious injuries. Where the prognosis exceeds 2 years, serious cases, they fall outside the tariff. We've reviewed and updated the previously published figures to account for inflation. We've also added a 3-year future-proofing element to ensure they don't move out of alignment with future inflationary pressures before the required statutory review in 3 years' time, and that leads to an increase of about 11% over the figures previously provided to the House. The reason for the uplift for up to 20% in exceptional circumstances is to balance the need for an effective tariff while also providing for judicial discretion. That 20% figure considers feedback received during consultation and in earlier debates, and reflects similar jurisdictions such as Italy, which allow for an uplift of up to 1/5. During the passage of the Act, we introduced, on the advice of the House, amendments to ensure that the views of the Lord Chief Justice were sought, and we have undertaken this consultation, and we are grateful to the Lord Chief for his consideration of these matters. The Lord Chief Justice was clear that the tariff figures, quotes, demonstrate a material diversion in the level of damages between those proposed and those which are generally currently awarded. He also acknowledged that the tariff figures are similar to those previously tabled before Parliament, at which time the Government's intent was made clear that the tariffs would be lower than the figure in the Judicial College guidelines. He emphasised the tariff was a narrowly defined statutory derogation from the principle of full compensation through an assessment of damages by the courts, but considered that it was not appropriate for him to suggest a change. And he made clear he understood the Government's principles underpinning the uplift, but expressed the view that he would prefer the judiciary to have greater discretion. And following receipt of that response from the Lord Chief Justice, further discussions with the legal advisers to the Joint Committee on Statutory Instruments led to a need to amend the tariff figures to distinguish between damages for claims for whiplash injuries alone and claims for whiplash injuries and minor psychological injuries. We made the Lord Chief Justice aware of these represented figures, and he was clear that his response in substance remained the same. He also considered that it would be beneficial to review the tariffs earlier than the statutory 3 years. We don't know now whether we will have enough data in a year's time to make an informed assessment, so I can't commit to an early review, but we are open to the possibility. We must first make sure there is evidence available to undertake a meaningful review from which effective conclusions can be drawn. So, having considered the points made by the Lord Chief Justice, we will not change our position on the tariff amounts or the judicial uplift of 20%, but we will undertake an analysis of the available data after a year with a view to considering whether an early review is appropriate. Turning to the medical evidence, the regulations provide that where a claimant lives or is examined in England and Wales, they must obtain a fixed cost medical report from an accredited medical expert selected via the Medco portal. If there are other more serious injuries, the expert has to be listed on the General Medical Council's specialist register. The other regulations relating to the Financial Conduct Authority give powers to the FCA to enable it to take effective action to monitor and enforce compliance with the ban on seeking or making pre-medical offers to settle. And the FCA is the regulator for insurers and claims management companies who may be involved in settling whiplash claims, and these regulations therefore ensure that the FCA has the powers it needs to regulate Section 6 of the Act. To conclude, my Lords, I would emphasise that the measures contained in these regulations are both necessary and important. They will provide certainty to whiplash claimants, create savings which will be passed on to consumers, and they enable the FCA effectively to regulate the ban on the offering and seeking of offers to settle whiplash and associated claims without appropriate medical evidence. And I hope that on this basis the committee will be able to support the measures. I therefore commend them to the committee.
The question is that the Grant Committee do consider this instrument. The next speaker, Baroness Primarolo, has withdrawn, so I call Lord Hunt.
My Lords, I first declare my interest as a partner in the global law firm DAC Beechcroft and also as set out in the register. I support these regulations. The structure of a modest tariff for a modest injury is exactly what was anticipated when the Civil Liability Act was debated in Parliament in 2018. I therefore agree with my noble friend the Minister that the tariff is set at the right level to reflect what these cases are really worth. The Judicial College guidelines don't tell us what hundreds of thousands of simple low-value claims settle for outside court. The JCG also do not exercise any form of control. They simply record what other judges previously thought over the years and uprate for inflation. The number can go up, but never slip back, as the guidelines themselves admit. But in conclusion, I just raise one further point with my noble friend, the Minister, which I made to his predecessor during the passage of the bill, about other minor injuries outside the tariff. The value of these other minor injuries is not the subject of any tariff. So can my noble friend provide an assurance that where they fall to be assessed alongside the tariff, their value will not suddenly become disproportionate to the main whiplash injury? Thank you.
I call Lord Etherton.
The digital portal for whiplash claims will be a completely new portal for small personal injury claims arising from traffic accidents where the pain, suffering and loss of amenity element is under £5,000 and all elements of the claim are less than £10,000. It is specifically designed to enable potential claimants to state their claim and avoid court proceedings without the assistance of legal advice. The idea being that the litigant will simply follow the instructions on the screen. It is likely that very large numbers of claims, running into hundreds of thousands, will be processed through the new whiplash portal. As the Noble Lord the Minister said, the Act itself, 2018 Act itself, provides for the tariff of damages to be reviewed every 3 years. And he's indicated that now, after a year, consideration will be given to whether or not there should be an earlier review than 3 years. My focus today is not on that review, but rather on the absence of any provision for collecting data as to the operation of the digital technology so far as the claimant is concerned, and a review of how well it is working. The Whiplash Portal and Protocol are not part of the court's digitisation reform programme, but arise out of a government policy initiative. I would urge the government that it should nevertheless, like court digitisation reforms, such as the online civil money claims digital process for small money claims by litigants in person, provide for litigants to record their satisfaction or otherwise with the procedural technology. This is particularly important in the case of the Whiplash Portal, not only because the litigant is expected to be able to navigate the new digital technology without legal advice, but because the technology has been developed not by HMCTS or the MOJ, but by the Motor Insurance Bureau. I would, for the same reasons, urge the government to carry out a review of the operation of the new portal within 9 months of its commencement, informed by the views expressed by the users of the portal.
I call Lord Aberystwyth.
My Lords, I declare my interests as set out in the register. My Lords, it's a great pleasure to follow the noble and learned Lord Etherton. My Lords, can I thank my noble friend, Lord Wolfson of Tredegar, for setting out the purport of these regulations so clearly. Indeed, the noble Lord wrote to noble Lords in February of this year, setting out the plans for whiplash reform. My Lords, I strongly welcome the reform and these regulations. I recognise, of course, that there are genuine whiplash claims, but it's known that there are many creative claims. These regulations will help to deter these, and it's estimated will result in approximately £1.2 billion worth of savings and save around £35, as the noble Lord, the Minister, has said, per average on motor insurance premiums, which insurers will pass on. My Lords, the provision of a tariff for damages payable for pain and suffering and loss of amenity is welcome. It's obviously central to require a minimum of medical evidence and a ban on settlement without medical evidence, and this is indeed provided for in these regulations. It also seems sensible to me to provide for a discretionary uplift of up to 20% for appropriate exceptional circumstances. The small claims track limit being raised to £5,000 from £1,000 is also very sensible. My Lords, the Association of British Insurers has mentioned that the reforms are very welcome, but it cautions that the potential for claimants to focus increasingly on additional minor injuries, as my noble friend Lord Hunt has pointed out, may result in higher awards than the tariffs for whiplash. I hope that my noble friend will be able to say something about keeping ahead of the fray on these developments, which could dilute the beneficial effect of these very welcome reforms.
I call the next speaker Lord Hope.
My Lords, I spoke in favour of what is now Section 3 of the Civil Liability Act 2018 when it was before this House 3 years ago, and I've not changed my mind. It seemed to me that the case for this measure, the whiplash injury regulations as we now have, was compelling. It was far too easy for claims to be made which would not survive scrutiny if they were to be adjudicated on by a court. They were being accepted by insurers because it was so much cheaper for them simply to pay up. Human nature being what it is, not everyone abides by the rules. There was an abuse here that needed to be dealt with. The decision to proceed in this way was taken then, and what we're concerned with now is the content of these regulations. My Lords, there's no getting away from the fact that the figures listed in each of the columns in Regulation 2 are quite modest. Indeed, some people have described them as derisory. We have them, however, in the columns before us. And I have to say that I welcome very much the noble Lord the Minister's assurance that he accepts the Lord Chief Justice's recommendation that a review in the light of experience will be undertaken in relatively early course after 1 year of experience. I think we can note, of course, the opportunity for the court to increase the amounts payable by up to 20% in exceptional cases. And we should note, too, that Section 3, subsection 8 of the Act, quite rightly, provides that nothing in that section prevents a court from awarding an appropriate amount for any other injuries that the person may have sustained, which may well be the case in the ordinary road accident situation. My Lords, there is a risk, of course, that other kinds of minor injury will now take the place of whiplash claims, and that will need to be carefully watched. For now, however, modest though the figures are, these regulations have my support.
I call Baroness Gardner of Parks.
My Lords, I welcome the introduction of the whiplash injury regulations, given the sheer volume of whiplash claims that were being made to exploit the system rather than to support those who suffered genuine injury. I do hope that any savings will be passed back to insurance policy holders as a reduction in policy premiums, as they've been paying for many of these unscrupulous claims with increased policy premiums for decades, rather than just absorbed by the insurance industry. My concern with the introduction of the official injury claims portal, a move to an online service, which is very much the norm these days, is whether this will disenfranchise many in society who would otherwise be eligible to make a successful claim. Can the Minister comment on how those who do not have online access or IT skills, as it is still all too often the case with much of society, are to make their claims, and if there is a paper version that will be an alternative? In addition, could the Minister outline to the House how these changes to claims are going to be advertised or communicated together with any paper version availability? Thank you.
I call Baroness Ritchie of Downpatrick.
My Lords, I welcome the reform of whiplash injuries compensation because in many instances, the accumulation of the payments for whiplash injuries which in many, many instances are very painful to those who have to endure them for a long period of time. But they imposed a considerable level of premiums on ordinary insurance people. So these regulations are supported by the insurance industry, as they have long campaigned on the need to tackle the UK's whiplash epidemic and have provided funding for the full technical development and build of the new portal through the Motor Insurers Premium. However, my lords, the Solicitors Association are lukewarm in their attitude towards the new regulations. They contend that the new tariff rates are fundamentally flawed in the methodology used in their formulation, leading to a substantially greater reduction in damages payable to injured claimants than is justified. They also believe that the proposed tariff of damages is unfairly low, given the possible severity and duration of the injury sustained. So therefore, in this instance, I would like to ask the Noble Lord the Minister, would he and colleagues consider publishing the correspondence and exchange of views with the judiciary in the interests of transparency, because there is a view that as part of the consultation process that not all the information from the judiciary has been made available? And would he also indicate what steps will be taken to ensure that the tariff rates are increased to facilitate fairer damages to injured claimants? And in this instance, I mean people who are deserving of this payment and have had to endure so much pain and suffering. Thank you.
I call the next speaker, Lord Thomas. Lord Thomas.
As I said 3 years ago, during the committee stage, I broadly welcome a tariff-based system. But today, as then, I wish to raise points in relation to advice, the proper operation of the new system, and the adequacy of the tariff. I spent 20 minutes this morning watching the video of how this system was to work for unrepresented defendants. It is not easy, and the experience elsewhere has shown that devising a system whereby people can make claims online on something that isn't very straightforward is difficult. I therefore wish to ask my Lord the Minister, what provision is being made to help unrepresented defendants understand the system, particularly those who are not as familiar with computers as members of their Lordship's House? Secondly, what advice will be given when a person has to decide whether the offer made by the insurers is a fair one? That is not an easy question. Will it be the CAB or some other third sector provider? And what funds are being provided to cover this additional cost of the third sector, bearing in mind the immense pressure on the third sector? It appears that the system that's been made has been, as the noble and learned Lord Etherton has stated, designed unusually by the potential defendants. It is clear, in my view, that an independent review of the operation of the system itself, as distinct from the tariff, is needed. And I very much hope that a properly independent review can be set up within a year. There should be no difficulty with needing the requisite figures. We just want to know, how is this dealing with unrepresented defendants? As to the review of the tariff, I hear what the noble and learned Lord the Minister has said, but I very much hope that whatever timescale the review takes place, it will be both independent and the evidence will be published.
I call Lord Naseby.
My Lords, I support these regulations. The objectives are good and clear. Perhaps on reflection, it's a pity it's taken so long, 4 years for action. It's good to see Her Majesty's Government working closely with the ABI, and they in turn with their members. And it's good to hear that everyone's organised when the portal goes live on the 31st of May. I like the linkage between the Treasury and the FCA and the industry, to assess whether policyholders have benefited from any savings made by insurance as a result of the Act. However, I am deeply concerned about minor injuries claims. There is the potential here for a huge challenge of quasi-bogus claims from claims management companies and claimant lawyers. And I say that because we already have evidence from earlier debates about what is happening in relation to credit lending, particularly payday lending and the backlash on home credit, collected credit, a format that's been with us for well over 100 years. And what's happening is these paid claims management companies manufacture complaints, use social media marketing techniques to farm spurious claims in large volumes, in fact, huge volumes. They end up at the Financial Ombudsman Service, who in itself finds itself facing this mass dumping of claims and have to produce what they call mass settlements, which are passed on then in the cases that we've been debating elsewhere with the actual companies who are doing the lending. In this case, they would be dumped on the insurance companies. So I ask my noble friend to make sure that he is fully briefed on what has been happening in what in effect is an allied industry.
I call the next speaker Lord Bettier.
My lords, this essay has been prepared by the Treasury. The Civil Liability Act 2018 gave powers to the Financial Conduct to enforce the ban on the making and requesting of offers to settle road traffic accident, whiplash-related injury claims without a medical report, as set out in Section 6 and 8 of the Civil Liability Act 2018. Entire instrument applies to England and Wales only and is a financial instrument for the purposes of standing orders of the House of Commons relating to public business. My lords, the territorial extent of this instrument is England and Wales. As set out in Section 6 of the Act, all low-value RTA whiplash-related claims will need to be supported by a medical report provided by a MEDCO-accredited medical expert, otherwise known as a ban on the pre-medical offers. MEDCO is a system for accrediting medical experts and for sourcing initial fixed costs of issue injury medical reports mandated by the pre-action protocol for low-value personal injury claims in road traffic accidents. My lords, the requirement to make sure that a medical report is completed before any PRA whiplash-related claim can be settled will provide more certainty to the costs of the settlement process. It will provide both parties with information as to the severity of the injury and an accurate assessment of the treatment required and or duration of the injury, so as to be able to assess their position on the tariff and identity the compensation payable to settle the claim. This will mean an end to the practice of pre-medical offers to settle, which can lead to unmeritorious, minor or exaggerated claims being made by some claimants, including fraudulent claims by uninjured claimants. This will also produce risk of under-settlement, as the policy will ensure that claimants with genuine injuries are properly assessed by accredited medical experts.
My lord, can I ask you to finish now, please?
Thank you. Appropriate to the level of the health of insured. Thank you, my lords.
Viscount Ridley has withdrawn, so I call Lord Bradshaw.
My lords, I spent, I think, 12 years of my life on a police authority, and I saw the manufacturing of totally spurious claims from a large number of ill-motivated people. Some of them were actually criminal claims. People had actually manufactured crashed cars and claimed that whiplash had taken place. And it was extremely difficult to deal with these. My view is that what the government is proposing is necessary. In fact, it's a pity it has taken so long to bring it into effect. I would, however, share the reservations made by Lord Naseby that there is a claims industry in this country which is determined to find somewhere where they can make money, and the money is made out of honest people who pay the premiums or pay extra as a result. I warmly support what the government is doing, but I would ask the Minister, as Lord Naseby has, to give us some real assurance that the government is alive to the fact that the people making these claims will move to other areas and will seek to exploit them. And I think a responsible government should be alive to this fact and should take steps as soon as possible to crush any resurgence of claims from any other quarter. Thank you.
I call Lord Ponsonby.
My Lords, tackling fraudulent whiplash claims to bring down motorists' insurance premiums is a welcome step. However, these efforts must not be at the expense of access to justice by genuine claimants. My Lords, we on balance within the Labour Party support the intention of these regulations. However, we are concerned that there may be a lack of clarity and that there should also be proper support for the inevitable rise of litigants in person. My Lords, we've heard something of the background to today's regulations from the first proposal in 2015 in the autumn statement plan, and there are plans to introduce a fixed tariff for whiplash claims resulting from road traffic accidents. The Noble Lord the Minister has explained that they will increase the financial limit of claims managed through a small claim from £1,000 to £5,000 and introduce a new online portal managed by the Motor Insurers Bureau for the processing of claims. The Minister also explained that they will set the maximum damages for whiplash claims limits, although a court may apply discretionary 20% uplift in exceptional circumstances. Also, children and vulnerable road users like pedestrians or cyclists or horse riders are excluded from the new regulations. The plans have been welcomed by the Association of British Insurers, as it's right there should be an effort to reduce the cost of whiplash to insurers, and that is currently about £2 billion. And I have to say, I thought the contribution by Lord Bradshaw with his time on his local police authority was very apposite and really went to the heart of the problem that these regulations are seeking to address. My Lords, I, like all other Noble Lords speaking in this debate, have been contacted by a number of interested bodies, and they've sent in a number of questions, which I will run through some of these questions, which I'm sure the Noble Lord the Minister will be aware of their concerns, but nevertheless, one question is, how will mixed claims be dealt with, where whiplash has been sustained along with other injuries? Another further question is, exactly under what circumstances may a judge apply the discretionary 20% uplift? A point which was made by Lord Etherton and Lord Thomas was regarding the new portal And the first point is I trust the data can be securely transferred to the new portal. But will there be proper reviewing of the data within this new portal so that a revision and a review of the new system can be undertaken from an informed point of view? A further question is, how does the government propose to address inconsistency in the application of these regulations? And the final point which I wanted to make has actually been made by a number of, much all the noble lords in today's short debate, and that is a concern raised by the Association of British Insurers, which is there may be an incentive for some people to claim on minor injuries and put that at a higher importance than whiplash injuries, and it would be there would be a danger that this could limit the effects of the reforms and lessen the benefits to those honest premium paying customers through this increase in minor injury claims. My Lords, in his introduction, the Minister said he was open to the possibility of a review, and I was wondering whether the noble Lord can give any indication of when he thinks it would be appropriate to review these new regulations.
I call the Minister, Lord Wolfson.
My Lords, I'm grateful to all noble lords who've taken part in this debate. Given the time constraints, rather than give a speech in response, may I try to deal with the various points that have been put to me. My noble friend, Lord Hunt of the Wirral, and also my noble friends, Lord Bourne of Aberystwyth and Lord Naseby, made the point that there is a risk that the regulations could be subverted by other injuries suddenly becoming the main injury. As the noble and learned lord, I think it was Lord Thomas, Lord Hope of Craighead, mentioned Section 3.8 of the Act provides that where a claimant suffers injuries in addition to a whiplash injury, the court is not prevented from awarding damages that reflect the combined effect of the injuries sustained. The courts, therefore, will need to determine how mixed injuries are addressed. We are confident that judicial expertise will address these matters on a case-by-case basis, but we will be looking vigilantly to ensure that the regulations are not undermined, whether by the claims management industry or otherwise, by people reordering their claims so that minor injuries become the main part of their claim. Noble and learned Lord Etherton asked about legal advice. The short point is that the online system has been designed with the claimant firmly at its heart. It produces a modern, user-friendly digital system. There is guidance in the system, and digitally disadvantaged claimants who can't use the system can be assisted by a dedicated telephone support centre. We will review the data which is produced by the system, and we will monitor it. We will be discussing the operational performance of the portal on a regular basis with the user group, including representatives of claimants and defendants, together with third sector and consumer representatives as well. The noble lady Baroness Gardiner of Parks asked about passing on savings. The short point there is that the competitive nature of the motor insurance market will ensure that savings are passed on, and as she is aware, the regulations provide that insurers have to provide data to the FCA so that the FCA can see the savings that are being made. And I can assure her, I don't want to repeat what I've just said, but we are very conscious of people who are not online, and we want to make sure that they are not disenfranchised. The noble lady Baroness Ritchie of Downpatrick asked me about the correspondence with the Lord Chief Justice. I hope I gave the committee a fair summary of that correspondence. We do not plan formally to publish the letters received from the Lord Chief Justice. It would not, I would venture to suggest, be appropriate to commit to publishing the full correspondence without discussing it with the Lord Chief Justice. And it's also important that these discussions can take place on a proper basis. As to a review of the tariff system, I hope I set out in what I said earlier in introducing these regulations that we will consider a review on the timescale which I indicated. I do appreciate, as she said, that some solicitors think the tariffs are too low. I'm afraid that is a debate which we've had on a policy basis on a number of occasions, and for the reasons I've set out, the government is confident that these tariffs are appropriate and give proper compensation where injuries are properly sustained. I hope I've dealt with the point made by my noble friend Lord Bourne of Aberystwyth, and I've also already referred to the contribution from the noble and learned Lord Hope of Craighead. I welcome his support on this matter very much. The noble Lord Bartier asked about medical reports. I can assure the committee that the online system is fully integrated with Medco, so that once a liability decision has been received by the at-fault insurer, claimants can proceed through the system to obtain their report from an accredited medical expert. And importantly, if the at-fault insurer has accepted any portion of liability, they will also pay for that report. And we've worked very closely with Medco to ensure that reports are presented in an accessible, user-friendly format, while it continues to include all necessary information on the claimant's injury and prognosis. We will ensure, as I've already said, that unrepresented claimants are fully supported through the process. The noble and learned Lord Thomas of Cumgeath asked me a number of questions. First of all, about the online system, and the noble and learned Lord referred in particular to unrepresented defendants. I don't know whether the noble and learned Lord actually meant unrepresented claimants, who I've already dealt with. But so far as defendants are concerned, I can assure the committee that a full programme of webinars has been undertaken where professional users can learn more about the new process and ask questions. Information has been regularly disseminated through an e-shot programme and through social media channels such as LinkedIn and YouTube. Additional information pages will shortly be available on Gov UK, and third sector organisations have been taught about the new online service, and therefore they will be able to signpost people to it. And I'm confident that once the system's up and running, it will run well. I hope I've also dealt with the point made by the noble and learned Lord about the tariff, and I hope I've also dealt with his point about a review of the system. I've sought to make the government position clear on that, and also as to the data point. But if I have misunderstood his focus as to defendants or claimants, I will perhaps write to him to set out the position in more detail. The noble Lord Bradshaw regretted that it's taken so long. I'm very conscious that this debate precedes my involvement in it by some years. All I can say is that we have got here, and the regulations will be up and running shortly. Better late than never. The important thing now is to make sure that they work properly and fairly, and that's certainly what we will do. I am absolutely alive to the fact that there is a claims management industry, and they will shift their focus. We will be equally vigilant to ensure that the purpose of these regulations are not undermined. And I therefore welcome, if I may say, the support in principle of the noble Lord Ponsonby of Shulbreed with the aims of the regulations. He asked me, I think, 6 questions in a rat-a-tat way. Let me give equally speedy responses, because we're all limited for time, I understand. First of all, as to mixed claims, I hope I've dealt with that. That's a Section 3.8 issue. The 20% uplift. All I would really want to say is that the word used in the statute is exceptional. I don't think it's appropriate for me to gloss that word, especially as we now have pepper and heart. So I think I should just say that that word is an ordinary English word and falls to be interpreted in the normal way. The third point, as to the portal, yes, I can assure the Noble Lord that data is secure, and I've already explained, I hope, the the timing rather, of the review, that we will keep that under. We'll keep the question of the extent and timing of the review under review. We will look at it in a year's time, as I've already said. I didn't, I'm afraid, quite understand the point about, I appreciate it wasn't the Noble Lord's point, but he was passing on a point, about an inconsistency in application. The whole point here is that we have a tariff. And so similar injuries really ought to be dealt with in very much a similar way. But if those who passed the question on to him are not satisfied with the answer I've given, perhaps he will reformulate the question to me, and if so, I'm happy to provide a written response. But there shouldn't be inconsistency because we have a tariff. The fifth point was that there would be an incentive to claim that the minor injury is in fact the main one. I hope I've dealt with that point already. And his last substantive question was as to the review, and I hope I've dealt with that as well. My Lords, I apologise for running through this at something of a pace, but I only have 10 minutes, of which I have about 15 seconds left. So I hope I've dealt with all contributions. I will check the report and write if I haven't. But otherwise, my Lords, I respectfully commend these regulations to the committee.
The question is that the Grant Committee has considered this instrument. As many as are of that opinion shall say content. Content. The contrary not content. The contents have it. Civil Liability Act 2018, Financial Conduct Authority, Whiplash Regulations 2021. Lord Wolfston moved formally. The question is that the Grand Committee has considered this instrument. As many are of that opinion will say content. Content. The contrary not content. The contents have it. My Lords, the Grand Committee stands adjourned until 3:35.
The proceeding is currently suspended. 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 The proceeding is currently suspended.
My Lords, motion to take note of the report from the Science and Technology Committee, Forensic Science and the Criminal Justice System, a blueprint for change. The time limit is 3 hours. I call Lord Patel.
Unmute. My Lords, it is a pleasure to move today's debate on the Science and Technology Committee report on forensic science and the criminal justice system, a blueprint for change. The committee is indebted to all those who provided written and oral evidence. We held 21 oral evidence sessions and 50 witnesses and received 103 written submissions. I thank them all. I also thank the committee members, our committee clerk, Donna Davidson, who I'm delighted to see is the table clerk for today's debate, to whom goes the credit for a well-written report. Our policy analyst, Dr. Daniel Rathbone, and our committee clerk, Cerise Burnett-Stewart, as always, an efficient organizer. We were also fortunate to have our specialist advisor, Professor Ruth Morgan, director at UCL Center for the Forensic Services and professor of crime and forensic science, an internationally recognized expert in forensic science and its application in criminal justice systems. Her advice and knowledge contributed much to the report, and I thank her most sincerely. I'm indebted to them all. I'm grateful also to the Minister, the Noble Baroness Williams of Trafford, for taking the debate today, knowing her very busy schedule of legislation. The Minister was also kind enough to meet with me and others to discuss the report following its publication, but more of that later. But I thank her for listening. My Lords, over the last 10 years, there have been 9 reports on forensic science and criminal justice system to improve the services and yet adverse reports in virtually all aspects of the system continue. Our report, based on evidence we received, addresses the whole subject in a holistic way. The key aspects of our report was the importance of addressing the whole forensic science system to identify the root causes of failures in the current system and to find best steps forward. My lords, the delivery of justice depends on the integrity and accuracy of forensic science evidence and the trust that society has in it. The quality and delivery of forensic science in England and Wales is inadequate. We heard this repeatedly in our inquiry. In our 2019 annual report, the Forensic Science Regulator urged that the focus of the government should be on the protection of justice rather than historic or current policies. One of the recurrent criticism we heard was the lack of high-level leadership and oversight of forensic science from the Home Office and the Ministry of Justice. The strong evidence led us to recommend establishing a forensic science board to deliver a new forensic science strategy and to take responsibility for it in England and Wales. Budget cuts, reorganizations, and exponential growth in need for new services, such as digital evidence, has put forensic science providers under extreme pressures. The result is a forensic science market which is dysfunctional, which, if not properly regulated, would soon result in major forensic science providers going out of business and putting justice in jeopardy. The government has an opportunity, following the recent much welcome legislation establishing the Office of Forensic Science Regulator on a statutory basis, and with the pending appointment of a new regulator, to give the regulator the resources and function of regulating the market. I hope the minister feels able today to agree on this. But if she does not agree, can the minister say who should be responsible for regulating the market? My lord's structural and regulatory muddle continues to exacerbate the malaise even now. There is no consistency in the way 43 police forces commission forensic services. Some doing so in-house, others contracting it out to unregulated private providers with no quality controls. Police forces also differ in which specialisms they outsource and which they keep in-house. This also calls into question equitable access of evidence for defendants, raises issues over the quality of analysis undertaken and the evidence presented. It is urgent that the forensic science regulator be given a number of statutory powers to bolster trust in the ability of forensic science and the quality of forensic science provision. So I asked the noble lady, the minister, will the government use the opportunity provided of the appointment of a new regulator to give her or him these powers? Fair access to justice for defendants is further hampered by cuts to legal aid. The defense needs to have an opportunity to commission its own forensic testing where the evidence is disputed. Further, the rapid growth of digital forensic evidence presents challenges to criminal justice system. We were not presented with any evidence of any future strategy to deal with this. The government has recently increased funding, but it still falls short of who will be responsible for developing longer-term strategy. Lack of resource and poor coordination of research and development in forensic science has resulted in concerns about the scientific validity of some of the forensic science evidence, particularly with regard to interpretation of the evidence. It is vital that the failings identified by our report is recognized. Otherwise, public trust in forensic science will continue to be lost, threatening confidence in the justice system crimes may go unsolved and run the risk of increasing the number of miscarriages of justice. Our report was published on 1st of May 2019. The government responded to the report in July 2019. The government's response was to only address one part of the forensic science ecosystem, not addressing the other key issues identified in the report. The proposals as set out in the government's response are insufficient to address the systemic issues and fall way short of addressing the core challenges or provide a path to forward look that will lead to reform across the whole of forensic science and enable the science to effectively assist the justice system. Some things have changed since then, although not much for the better. All the opportunities do exist even now to address some of the failings identified in our report. Let me briefly say what has changed. One of the key good news, of course, is the establishing the Office of Forensic Regulator on a statutory basis, and I thank the Minister for that. What is lacking is the regulatory powers that the regulator needs to drive the changes required to make the provision of forensic science in England and Wales world-class as it once was. There is also a need to address the level of resources required for the regulator to do his or her job. I hope the Minister can comment on that. Instead of the Forensic Science Board recommended by the committee, the Criminal Justice Board has formed a forensic subgroup to address a forensic science reform program, to strengthen forensic science provision and address key risks and challenges. It is not clear, though, how far it has progressed and what role and responsibility does the government play in it. Despite further incidents, such as cyber attack on one of the providers of forensic services, the issue of fragility of the market is not being addressed. The government has put more money into the Transforming Forensics program and launched its delivery arm, the Forensics Capability Network. But several police forces remain skeptical of the effectiveness, as evidenced by a request by the National Police Chiefs Council for a review. Accreditation and meeting quality standards and training still remain as issues, as does inequality in availability of the forensic services to defendants as opposed to prosecution. Cuts to legal aid, as I said, threatens financial viability of those that provide legal aid to defense. To date, there have been some positive conversations in relation to funding for forensic science, research and development, but very little progress is being made. I will try and conclude, but before I do, I have further 3 questions for the Noble Baroness, the Minister. Where in the government does the accountability lie for provision of quality of forensic services to assist the justice system? Who will be responsible for regulating the market in forensic services? How will the government be assured that UK remains at the forefront of research and development and forensic science methodologies, including digital forensics, foundation research, and importantly, the interpretation of forensic materials? My Lords, I end by a quote from one of our witnesses, Professor Claude Roux, director at the Center for Forensic Science in University in Sydney and president of the International Association of Forensic Scientists, said this, referring to all aspects of forensic services in England and Wales. He said, and I quote, "England and Wales held essentially the international benchmark in forensic science. It was the mecca for forensic science. 30 years later, due to ongoing national crises, it is more an example not to follow." For the committee, that was not pleasant to hear. My Lords, I beg to move and look forward to the Minister's response. Thank you.
My Lords, may I remind noble Lords that some members are here in person, others are participating remotely, but all members will be treated equally. And I ask members in the room to respect social distancing. And if the capacity of the committee room is exceeded or other safety requirements are breached, I will immediately adjourn the committee. If there is a division in the House, the committee will adjourn for 5 minutes. My Lords, the question is that this motion be agreed to. And I call the next speaker, Baroness Warwick.
My Lords, it's an honour and pleasure to follow Lord Patel in his comprehensive introduction to the debate. His speech got right to the heart of the dilemma the House faces in judging the adequacy of the government's response to the committee's report and recommendations. After weighing all the evidence presented, the committee saw the need for systemic root and branch reform across the whole of forensic science if it was to play an effective role in assisting the justice system. The government has chosen not to take that strategic view. Rather, it has focused on just one element and only one part of the report, the creation of statutory powers for the regulator. Welcome though that is, unless there is an increase in the regulator's scope and powers, and unless there is a body responsible for driving and implementing strategy, I fear little will really change. My Lords, I joined the Science and Technology Committee only this year, so wasn't involved in the production of this excellent, hard-hitting report, but I've read it and much of the evidence. Its findings shocked me profoundly. I suspect other members of this House may, like me, have largely gained awareness of the role of forensic science in the criminal justice system from the limited coverage in the news media. I understood the received wisdom to be that we had a world-class system. But whatever confidence this had given me in the competence of the service, its scientific base, or in the reliability of its judgments, that confidence was shattered by this report. The main conclusion of the Select Committee is that the quality and delivery of forensic science in England and Wales is inadequate. It highlighted an absence of high-level leadership, a lack of funding, and an insufficient level of research and development, which had all been exacerbated by the coalition government's abolition of the government-owned Forensic Science Service in 2012. It further identified the need for the regulator's powers to be expanded and made statutory, as the coalition government had promised. It was particularly concerning, my Lords, to note that there have been no fewer than 5 reports into the state of forensic science in England and Wales, 9 reports into the state of forensic science in England and Wales, all raising similar concerns to those raised in the Science and Technology Committee's report. But very little, if anything, has been done. As the report says, the delivery of justice depends on the integrity and accuracy of the evidence available. The inadequacies of the service are clearly endangering that integrity, as well as undermining public confidence. In its July 2019 response to the report, the government acknowledged the inadequacies of the system and seemed to be largely positive and apparently supportive of the committee's recommendations, so it was strange that the government seemed reluctant to accept the structural changes proposed by the Select Committee in relation to a Forensic Science Board to oversee strategy and a National Institute for Forensic Science to address the problems of under-resourcing in research and lack of coordination. My Lords, the committee's report is robust in its criticism of the lack of cooperation and coordination between the Home Office and the Ministry of Justice. The government agreed that there needed to be a joined-up approach, but that, and I quote, "Following the appearance of ministers from the 2 departments before their lordship, there's been much closer cooperation," end quote. Whilst this may be flattering to the immediate persuasiveness of your lordship's committee, there is nothing to guarantee that this new spirit of cooperation will be maintained, and indeed the lack of any action in the last 2 years does not suggest much has changed. Can the Minister tell the House how she proposes to ensure that collaboration continues and how she will evaluate its effectiveness. Similarly, in rejecting the recommendation for a National Institute for Forensic Science, the government relies on the two ministries, and I quote, developing an even stronger working relationship with UKRI to set strategic priorities for forensic science research and development. I wonder if the Minister doesn't agree that this is rather a loose arrangement. Indeed, this doesn't really seem any change from the current situation. In the last 2 years, some conversations have apparently been initiated with UKRI, but so far there has been no formal recognition that forensic science requires dedicated funding, and no progress been reported on the need for strategic oversight of research and development, or identifying funding to enable it. Will the Minister acknowledge the very significant lack of funding, less than 0.1% of UKRI spend over the last 10 years, and indicate how that will be resolved looking ahead? My Lords, I referred earlier to a change that the government has agreed. In the last few months, the government has been able at last to find parliamentary time for the Private Members Bill introduced in the Commons by Labour MP Darren Jones, and which we debated in this House last month, with third reading just last Thursday. It had full government support and in part addresses the recommendations in the Select Committee's report in placing the regulator on a statutory footing and gives the regulator powers to enforce a statutory code of practice. It's a great start, but as the chair of the Select Committee said at second reading, whilst most welcome, it was a missed opportunity to address the other issues identified by the committee and by the outgoing regulator and highlighted today by Lord Patel. I hope today's debate will prompt the Minister to go further. The delivery of justice requires it. The confidence of the public must be won back. So can I ask the Minister whether she will keep these matters under close and regular review so that further changes can be brought in as necessary? I hope she will agree that this is the only way to avoid yet a further future report which reiterates the concerns of the 9 previous ones, as well as the 10th one we're debating today from the Science and Technology Committee.
I call the next speaker, Baroness Walmsley.
My Lords, I was not a member of the Science and Technology Committee when this report was written, although I am now. I'm really sorry I missed it because it was clearly a fascinating and important investigation. However, having read the report, which was up to the committee's usual high standard of rigour and integrity, the main impression I gained was this. The forensic service in this country has become a shambles and regrettably has fallen a long way from its former high standard. The noble Lord Patel called it more politely inadequate and dysfunctional. This is bad in itself, but it is a particular disaster given the fact that the science is moving so rapidly in new directions and the demand for the service is growing exponentially, particularly in relation to digital evidence. My Lords, high-quality forensic science is crucial for the operation of justice. It is important to the accused, both guilty and innocent. It is important to victims, both existing and potentially in the future. It is important to the police, judges, and advocates to enable them to do their job properly. It is important to juries who need confidence in the quality of the forensic evidence to allow them to be as sure as possible about their decisions. And it is important to the public on whose behalf the criminal justice system works. But it is clear that for whatever reasons, not usually the fault of those who work in the service has let us all down over recent years and lost its former high reputation. The committee has done an excellent job in its report of getting to the bottom of what has gone wrong and proposing a comprehensive plan of what needs to be done to put it right. 4 aspects jumped out at me as I read the report. First, leadership and resources. The committee led with this issue in its very first recommendation. I absolutely agree with them that the service needs strong leadership at arm's length from government. They recommended a forensic science board to take the lead in strategy, organisation and regulation. The government instead proposed a less independent alternative, a steering group of the Criminal Justice Board, jointly chaired by the Home Office and Department of Justice. Hardly arm's length. Well, I'd like to ask, where is it? Does it exist? What has it done since the report in spring 2019? And do we have to wait another 2 years for action? Yes, we now have a statutory regulator, thanks to a private member's bill, but this is no use without adequate powers and resources. On powers, the committee listed 5 in their recommendation 12, all of them needed to enable the regulator to ensure the quality of provider organisations and individuals, and the ability to force them to improve or remove them from the service as necessary. It is outrageous that some providers are currently unregulated and some so-called expert witnesses not adequately qualified. The government did not agree with these recommendations, but I believe a regulator needs teeth. Otherwise, how can he or she do the job? It's nearly 10 years since the government promised the regulator would have such statutory powers, a time lapse which the committee described as embarrassing. Can the minister assure us that the government will take appropriate action so that it is no longer embarrassed? On resources, following the disastrous cuts to legal aid, the committee heard that the defence sometimes lacks the ability to commission its own forensic testing, where the evidence is disputed. And of course, on the prosecution side, the police need adequate resources to build their case. Some police forces use their own labs, some put the work out to private providers, and some a mixture of the two. But if you are going to put a public service out to the market, you are going to have to show private providers that there is a stable business there in which they should invest. But as the committee's evidence shows, the market is fragile and some providers may close down. The government's response is to reform procurement policy. This sounds to me like if you don't like the price of butter, you go to a different supermarket. Can the noble Baroness the Minister tell us what it actually means, apart from an attempt to get more for less? Secondly, accountability. It is currently unclear where accountability lies in government. I echo the noble Lord Patel's question. Can the Minister say clearly where accountability lies now? Is it with the steering group or whichever department happens to be in the chair at the time? And there's also a lack of coordination. The committee proposed that the new FSB should work with the regulator and the proposed National Institute for Forensic Science to ensure standards, strategy and coordination. Can the Minister say how the government's alternative structure will do this? Thirdly, research and forward planning. It's vital that there is a mechanism to look ahead and plan for investment in research into new forensic methods, and where appropriate, the use of artificial intelligence and automation, and the practicality of how these can be integrated into the service. In the past, the development of and confidence in DNA evidence has allowed former miscarriages of justice to be corrected and unsolved crimes to be laid at the doors of the perpetrators at last. If resources are not put into the development of new forensic science, there will be more miscarriages of justice and more unnecessarily unsolved crimes. Victims are always the ones to suffer for this, but so does the whole of society. This is where the committee's recommendation 21 of the National Institute for Forensic Science within UKRI come into the picture. Without such an expert group to do the horizon scanning and ensure the funding for the correct areas of research, the rogues will always be way ahead of the forces for good. Which brings me to staffing. The service does not just rely on new methods, but on high quality staff. Where is the planning and resources for staff training? Recommendation 13 and others cover this. The proposed Forensic Science Board would have the responsibility, together with the College of Policing and the Chartered Society of Forensic Sciences, to develop a strategy for the ongoing training of all forensic science practitioners, including those who provide expert evidence in court, and also providing CPD on forensic science for practicing lawyers. Given the rise in digital crime, it is essential that more staff qualified in this area are recruited. What system does the government propose for the staff planning and training function? And why is it better than the committee's recommendations? And finally, confidence. The Noble Lord Patel has outlined the delay and inadequacy of government response. It makes me wonder whether this indicates a lack of interest on behalf of the government, or perhaps a lack of understanding of the role forensic science plays in building the confidence of the public in our criminal justice system. Does the Noble Baroness the Minister agree with me that a high reputation for forensic science can have a beneficial effect on the willingness of the public to cooperate with the police? It can also affect the prevalence of crime, deterring potential criminals as well as catching them. Police chiefs, in their evidence to the committee, did not show that they have confidence in the government's response to the report. My lords, if they don't have confidence in the system, who can?
I call the next speaker, Earl Lindsay.
My Lords, I'm very grateful to the Noble Lord Patel for introducing the report from the Science and Technology Committee on Forensic Science in the Criminal Justice System. This is an important report, which has not only shone a light onto some of the current failings and inadequacies of the use of forensic science within the criminal justice system, it also makes important and much needed recommendations for change and improvement. My Lords, these recommendations are to be welcomed, and I very much hope they will be carefully considered by all those working across this complex and multifaceted discipline. I recognise that some of the actions have been progressed since the publication of the report nearly 2 years ago. And my Lords, it is particularly encouraging to note the successful progress of the Forensic Science Regulator Bill through both houses, with just royal assent now awaited. When enacted, my Lords, the Forensic Science Regulator, the FSR, will gain long overdue statutory powers. And at this point, my Lords, I should declare an interest as the chair of the UK's national accreditation body, UCAS. UCAS is the sole national body recognised by government for the accreditation of organisations against nationally and internationally agreed standards. It is in this capacity that I especially note the committee's conclusions relating to the clear benefit of ensuring that the majority of forensic science providers are accredited to the appropriate international standards. Accreditation delivers assurance of the impartiality and competence of providers, which I'm sure we would all agree is imperative within the criminal justice system. My Lords, I also welcome the recommendation that UCAS and the FSR work closely together to ensure that accreditation to relevant ISO standards is accessible and is progressed to ensure that the objectives of the FSR are realised. UCAS and the FSR have in fact been working closely since the FSR role was first created. Together, we have achieved consistent success in improving standards through the accreditation of forensic science providers in both the private sector and police forces, in line with the expectations of the FSR codes of practice and conduct. As the FSR powers evolve, UCAS will continue to collaborate closely to deliver the vision of the FSR, focusing on compliance with the required standards and, through the accreditation of forensic providers, the demonstration of appropriate competence of the practitioners undertaking this critical work. In addition, my Lords, UCAS and the FSR are able, through appropriate agreements, to share information, helping to support each other in their respective roles. The need for high quality and reliable forensic services with sufficient capacity and capability to deliver the services required is a given. They are critical for a fair and functioning criminal justice system. I therefore welcome and support the report's conclusions, calling for the delivery of strategic and accountable leadership, reflecting all the main stakeholders to set the vision, strategy, and agenda for forensic science. This leadership, my Lords, this leadership, vision, strategy, and agenda are needed now more than ever as the shape of forensic science evolves to accommodate new technologies and changes in the types of crime and evidence needing to be examined. The recommendation to focus on building capacity within the digital forensics market will likewise be imperative to keep pace with demand. My Lords, in conclusion, I thank the Noble Lord, Lord Patel, and his committee for the expertise and foresight that they have brought to this excellent report. My Lords, I add my support to their conclusions and recommendations.
Lord Mayor.
My Lords, it was a privilege to have been a member of this House's Select Committee on Science and Technology under the expert and excellent chairmanship of the Noble Lord, Lord Patel. I congratulate him on his wise leadership. Our report, published in May 2019, highlighted that this country was once regarded as world-leading in forensic science and seen as the international benchmark. But regrettably, this is no longer the case. We are lagging behind other countries. This is principally because there is an absence of high-level leadership, a lack of funding, and an insufficient level of research and development. Our inquiry repeatedly heard that the forensic science system in England and Wales is not operating as it should. It's inadequate and in a state of crisis. We heard consistent evidence of the decline in forensic science, especially since the abolition of the highly respected Forensic Science Service in 2012. The Noble Lord, Lord Patel, has outlined some of the principal recommendations of our report. One was the creation of a Forensic Science Board to take responsibility for forensic science in England and Wales. Another was the creation of a National Institute for Forensic Science to set strategic priorities for forensic science research and development, and to coordinate and direct research and funding. The government has decided not to implement either of these key recommendations, as noted by Baroness Warwick. I will focus on two important areas affected by this decision. Firstly, the market for provision of forensic services, and secondly, the research and development requirements, especially in relation to digital forensic evidence. On the first area, the market for provision of forensic services, the Noble Lord, Lord Patel, has rightly emphasised the urgency of giving the forensic science regulator a number of statutory powers. The proposed establishment of the Office of the Forensic Science Regulator on a statutory basis is much welcomed. Lord Patel drew attention to our inquiry, hearing evidence of a dysfunctional forensic science market. Our committee recommended that these statutory powers should include the means of regulating the market. The effectiveness of forensic science for the criminal justice system depends critically on who provides it and how accessible it is. It must be good enough to be relied upon by the courts, and it must be equally accessible to both the prosecution and the defence. Since the closure of the government's Forensic Science Service in 2012, some types of forensic science analysis are increasingly undertaken by police forces in-house, particularly disciplines such as fingerprint analysis and digital forensics. Our inquiry heard that the forensic marketplace accounts for about 20% of service provision for law enforcement in forensic services by value, with the remaining 80% of forensic science work undertaken by in-house employees of police forces. There's been a large reduction in spending on forensic science services. We heard that around £120 million being spent on forensic science in 2008 was down to about £50 million in 2018. Significant reduction in spending on commercial providers of forensic science has contributed substantially to market fragility. We were told by a number of witnesses that the state of the forensic science market in England and Wales was unsustainable and in need of urgent reform. A number of private forensic science providers had gone into administration or been suspended, leading to significant fluctuations in the market and consequent problems for the criminal justice system. Dr. Gillian Tully, until recently the forensic science regulator, stated in her 2019 annual report that there was, I quote, more needed to be done to stabilize the procurement and provision of forensic science services by police forces. Procurement of forensic services from private providers is largely run by the 43 police forces and their police and crime commissioners in England and Wales. A distinctive feature of the forensic science market is that in any given region, the police forces are essentially the sole customer. We heard evidence that commoditized procurement processes had led to a 30 to 40% erosion in pricing over 6 to 7 years. Suppliers of forensic services were being forced to compete so heavily on price because the contracts were so big and came around so infrequently. The result was prices being reduced to unsustainable low levels. My lords, we all know the dangers of this. The level of scientific skills offered by private providers of forensic services is inevitably compromised if they're being driven down to very low prices. In their response to our report, the government acknowledged that there is a strong relationship between price and quality. The key question, therefore, is how to rectify the current situation. Our committee heard how, as an alternative procurement model, some police forces are now using a managed service model. In this model, for a fixed price, a large provider contracts to provide police forces with all the forensic science services they need long-term for up to 10 years. Whilst this provides long-term stability for a large provider, it leaves little opportunity for the smaller specialist providers, many of whom are uniquely able to offer scientific analysis in important niche disciplines. Evidence we heard indicated that some important specialisms are dying out because they are no longer sustainable. This is worrying. Our report concluded that the current procurement models for forensic science services will need to change substantially in order to stabilize the market. The evidence pointed to the need for a body to oversee the market and ensure continuity of high-quality service provision. Without this, the criminal justice system will continue to be severely compromised. My lords, our committee recommended that the forensic science regulator should urgently, A, review the structure of the market for forensic science, B, review the procurement process for commissioning private sector providers alongside provision by police forces. The primary aim should be to determine a procurement model that balances price, quality, and market sustainability. It's particularly important to ensure a level playing field between private and public sector providers of forensic science services, maintaining the capabilities of small providers in niche disciplines. Can the noble Baroness, the Minister, give an assurance that the forensic science regulator will be given the necessary statutory powers to achieve this, overseeing and regulating the market effectively, ensuring its stability and its quality? The second and final area on which I would like to comment is research and development, especially in relation to new technologies and the increasing importance of digital forensic evidence. Digital evidence is now a key component in many criminal trials. Digital forensic capabilities must therefore be available to both the prosecution and the defense. Our committee heard that around 80% of all crime cases have a digital element, whether it be CCTV, mobile phones and social media data, or cyber attacks. Interrogating and analyzing digital evidence is becoming increasingly time-consuming. The evidence was clear that very considerable investment was needed in the use of modern technology to handle, search, and analyze digital content. Digital forensics is a rapidly expanding field. Its increasing importance is clearly recognized in the comprehensive Digital Forensic Science Strategy published by the National Police Chiefs Council in 2020. The value of artificial intelligence and machine learning to the criminal justice system cannot be overestimated. A modern mobile phone could have 1 terabyte of data on it, equivalent to many thousands of documents. Artificial intelligence and machine learning have vital roles to play in facial and speech recognition and in identifying patterns of behavior. There are enormous opportunities to apply artificial intelligence and machine learning technologies to streamline the handling, searching, and analysis of digital forensic evidence. However, there are complexities because human biases might be replicated by machine learning systems. This requires more research, particularly in the context of evidence for criminal trials. A further pressing complexity is the rapid rise of deep fake technology. It's now possible to create digitally altered videos or soundtracks that make someone appear to have done or said something that they have not done or said. Deep fake videos or soundtracks are becoming easier to make, but are dangerously difficult to identify as fakes. We're entering a world where it is no longer possible to believe all digital information. It is these very complexities that point to the urgent need for research in digital forensics. Our report recommended that UKRI, working with the Ministry of Justice and the Home Office, should urgently and substantially increase the amount of funding allocated to forensic science for both technological advances and foundational research. We emphasised the need to focus on digital forensic science evidence and the opportunities for understanding and developing further capabilities in artificial intelligence and machine learning. Can the noble lady, the Minister, confirm that the government recognises this vital need and will act accordingly? In summary, my lords, there can be no question that proper delivery of justice depends on the integrity and accuracy of forensic science evidence and the trust that society has in it. There are urgent changes needed to the system of procuring forensic science services to address market fragility, ensure stability, and maintain high quality. There is also a need for more funding to be allocated to research and development in forensic science, especially in the rapidly changing area of digital forensics. And my final point is this. Included in the title of our report,
I have to adjourn the meeting for 5 minutes for voting.
The proceeding is currently suspended. 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 The proceeding is currently suspended.
We resume proceedings, and I'm delighted to ask Lord Mayor if he would benefit us by saying the last couple of sentences or so of his remarks. Is Lord Mayor there?
I am indeed. Thank you. I was just about to conclude. My final point is this. Included in the title of our report were the words, "a blueprint for change." How much of the blueprint will really materialise? There are fears that only a few of our recommendations will be implemented. Substantial change is needed across the board if forensic science is to properly assist the criminal justice system. Full confidence in its provision needs to be restored.
Thank you, Lord Mayor. Sorry I had to interrupt you. I now call the next speaker, which is Lord Winston. I call the next speaker Lord Winston.
My Lords, the noble Lord Patel is to be warmly thanked for his chairing the Select Committee so ably and for getting this particular motion tabled finally. I declare I was not a member of the committee, but I am a member now of the Science and Technology Committee more recently. Forensic science and criminal justice is an extremely important topic, and the recommendations of the committee are of grave concern. And in this respect, it's regrettable it's taken for 2 years to debate this report. I suppose at least that one can say that not much has changed. We pride ourselves on in a civilized society at the heart of which is a stable democracy and a justice system which has rightly been internationally respected as a model. But it's obvious that major deficiencies have left some cruel results and some great distress, or even worse, to a number of people, often entirely innocent citizens. The delay in doing something more about this is an underlying problem, and it reflects extremely badly, in my view, on the government. Now, I'm going to address some of the issues I think that the noble Lord Mayor has already addressed, so I will probably illustrate my remarks in a slightly different way. I declare an interest as a member of the Centre for Data Ethics and Innovation, and last week the conviction of Josephine Hamilton and others was quashed on appeal. This litigation involved evidence depending on an antiquated computer system and out-of-date software. Earlier, Mr. Justice Fraser, in his written judgment, which extended to 313 pages, quashed the conviction of 39 sub-postmasters on the grounds that the commercial IT system which was used by Horizon and sold by Horizon and Fujitsu was unfit for purpose, in spite of the Post Office's assertions to the contrary. This software was based on a long unsupported version of Windows NT4, which was first launched in 1996. In computer parlance, that's not merely equivalent to the description of Chancery and Jarndyce in Bleak House by Dickens, but it's more close to Middle English of The Friar's Tale by Geoffrey Chaucer. And this, in spite of denial from the Post Office, subject to bugs, errors and defects. To compound the seriousness, Mr. Justice Fraser pointed out, and I quote, to see a concern expressed that if a software bug in Horizon were to become widely known, it might have a potential impact on ongoing legal cases where the integrity of Horizon data was a central issue. This, he said, was a very concerning entry to read in a contemporaneous document. And I agree, and it shows one of the problems with these commercial interests. There is another problem apart from the commercial interest. Most reasonably educated people think of forensic evidence with the precision and scientific certainty often given in the media. Line of Duty, Broadchurch, The Fall, True Detective, even The Night Of, and Silent Witness. This has encouraged many people, including jurors, to consider some evidence not as circumstantial evidence, but as certain evidence. This is certainly true of much biological evidence, for example DNA, to which I'll return in a moment, but even to the gait of a person, the shape of a skull, the cause of a fire, the use of a partial fingerprint. But in a sense, the importance of data and its analysis, as the Noble Lord Mayor has said, has now become increasingly central to the criminal justice system. The increasing difficulty raised by the analysis of extensive data in criminal justice is well illustrated in the case of the Crown versus Michael Richards, Robert Gold, Rodney Whiston-Dew and others. This commercial fraud involved over £200 million. It had been initiated some 10 years earlier. It involved setting up projects promoting sham attempts at carbon sequestration overseas, a complex network of a large number of wealthy investors, tax relief claims, offshore banking, and extensive fraud involving the Inland Revenue. During an earlier appeal heard by Sir Vivian Ramsey in 2013, the prosecution was stayed on the grounds of an abuse of process, partly because the prosecution had failed to comply with the duty of disclosure. There was a major difficulty. It's unnecessary to go into detail here, but the investigation and the subsequent prosecution had required terabytes of information, 85 digital instruments, and an additional non-digital material, which took some years to analyse. After the devices were returned to the respondents, HMLC kept digital information on file, and the respondents were then in a position to recreate the nature of their involvement. It eventually became clear to HMRC that the proprietary software needed to analyse all the digital information that they had taken was served by FTW version 1.7, and it didn't permit full optical character recognition. There were in all some 312,500 files, which were reviewed by people scrolling through thumbnail images. Subsequently, the information was migrated to a later version of FTW, version 3.4. But this was equally unsatisfactory because it required lengthy process and there were software problems which continued, and these deficiencies included, for example, the misplacements of attachments to emails. In the event, in a subsequent hearing in the Court of Appeal, the Criminal Division, chaired by Sir Brian Leveson in 2015, the earlier ruling was overturned. In some 33 pages, a very clearly expressed judgment was made by 3 judges. The appeal by the Crown, the prosecution was allowed, and the earlier stay was lifted. The case finally went to trial 2 years later, more than 10 years after HMRC had started its investigation. The key defendants were given lengthy prison sentences. The trial before Mr. Justice Edis, with presentation of those data, took 10 months, and it's notable that early in the trial, one juror found that she was pregnant. She was finally delivered of a baby girl, Evie, before the trial finished. Now, how much did this process cost? How much of the defrauded money was recovered? Perhaps the noble lady, the Minister, might inform the House after this debate, or perhaps write to me separately. But with the increase of litigation involving commercial crime, as Lord Mayor has said, and organised crime such as trafficking or illegal use of the internet, serious investment in digital technology and constant refurbishment of hardware and software is crucial, and the need for effective machine learning and artificial intelligence, as he has maintained very clearly, is essential. My lords, I'm just a doctor. I'm not a lawyer, as my imperfect description of this last case will confirm. But I did promise to return to biology and DNA before I conclude. This excellent report of the Select Committee has detailed the inadequate provision for properly set up forensic laboratories, the questionable qualifications and training of many technical staff, and the expense and problems arising when commercial companies tender for contracts with the police. One example of these problems which may arise is well illustrated by the Randox debacle. Randox Testing Services advertises on the web, as I checked this afternoon, for workplace testing, medical legal testing, and COVID-19 antibodies and PCR. I've not been able yet to find out how much they charge for this, but their website claims that they've undertaken 17% of the government's national COVID testing. Apparently, the police used to outsource most of their toxicology testing to them, and it is claimed that what happened was that some dishonest employees in their laboratories fabricated evidence of alcohol usage, and 10,500 cases, mainly involving drink driving, are being reanalyzed. The cost and delays involved in this are considerable. This investigation is still going on 2 years later. Retesting is apparently taking a long time because we're told there's a chronic shortage of scientific expertise and accredited laboratories, leading to delays in providing toxicology analysis in unrelated cases of sexual offence and of rape. This is just one example of the Select Committee's concern about outsourced laboratory testing in inadequately supervised commercial laboratories. Let me conclude, my lords, with DNA. In 1988, my own lab was refining PCR, the polymerase chain reaction, then an entirely new process to test human embryos for possible sex-linked disease and for any one of a number of 6,000 genetically diseases which cause serious or usually fatal disease in children and young people. It required exquisite care dealing with the DNA from just one or two human cells. Indeed, many colleagues told me that this would be quite impossible. It's now used worldwide. But all DNA of this kind, whether, for example, medical or forensic, requires exquisite months, if actually not years, our methods and redesigning at least one laboratory. The problem of contamination is serious, and it's also true of advanced spectroscopy, for example, when one's looking for chemical analysis, for example, of toxicological samples. With DNA, a tiny tube about 1 centimetre high can be contaminated by somebody touching apparatus nearby or somebody coughing 30 metres away from the tube. Now, we don't really know how long DNA, a stable molecule, apparently, will survive on a given surface, or how long it may, for example, be contaminated on a swab. DNA analysis has now become sophisticated and automated, but mistakes are still possible, particularly in untrained hands or in inadequate laboratories. And I fear to say that even in well-equipped premises, that can happen. Many years ago, in a totally different experiment, a colleague and I voluntarily withdrew a paper which had already been accepted by the international journal Nature, because we felt unsure we could replicate our results after lengthy storage of the DNA on which we had run gels. It's very clear, my lords, from this report that forensic science, yet another area in which the UK has led, is in dire straits due to underfunding, poor regulation, inadequate training, limited university courses which are seen as a cash cow, and scanty, meaningful research. There are too few properly qualified individuals and a very wide range of forensic specialities. This report is commendable because it clearly outlines many of the key issues. As Sir Brian Leveson, who gave evidence to this inquiry, has pointed out, inadequate or flawed forensics seriously undermine the system of British justice and the trust of the public.
Thank you. I call the next speaker Lord Griffiths of Forestfach.
Thank you very much. It's a great pleasure to have been a member of the Select Committee on Science and Technology at the time we undertook this investigation. And in this context, I'd like to thank in particular Lord Patel for his outstanding leadership. He was relentless as well as courageous in getting at the root of the problem. And I hope that he feels as a result that we served him well. I'd also like to thank the excellent contribution that our special advisor, Professor Ruth Morgan, made, not just at the time when we were meeting, but also in what she handed out before and as preparation for today's debate. At the outset, I'd like to make one point, namely to draw attention to the seriousness of the issue we're debating today. We live in the United Kingdom, in countries which uphold the rule of law and a legal system which aspires to deliver justice. As we wrote in the report, the integrity and accuracy of evidence is critical to ensuring public trust in our system. If that trust ever drains away, the consequences for our society would be enormous. And therefore, it's very important to stress that securing justice is really at the core of what we're doing. That it's not about the police simply having a very successful record of prosecutions, or entrepreneurs believing that the private sector should be intimately involved in provision, or that the science community feeling that the development of science is critical. What really matters is the reliability and the accuracy of forensic science in providing public confidence in our system. And in this context, I'd like to make 3 points. First, we made it very clear in our report that the fundamental weakness of the current system was at the highest level, namely to do with the relationship between the Home Secretary and the Secretary of State for Justice. We concluded that there was a lack of leadership providing a vision, strategy, and agenda for the whole of the Forensic Science Service. What we were saying was that we really need one umbrella which covers policing, the judiciary, and the defense community. And we heard again and again that the parent system, as we've heard this afternoon, is too fragmented, with parts entrenched in silos, and as a result, the quality of forensic science is not at present fit for purpose and not up to our traditional reputation. The reason we made this recommendation, which, as I've said, is foundational to our report, was based on the evidence we received. That was the evidence we received from ministers, though they may not have been so blunt as I've been today. That was the evidence we received from the forensic science regulator. 1 week before our report was published, the Home Office published a review of forensic science whose primary focus was the management of the market. But in addition, they said they recognized a broader set of issues which would have a significant impact on shareholders' confidence in the system. Then the government, in their response to our report, mentioned that they'd set up a steering committee jointly chaired by the Home Office and the Ministry of Justice, but its primary focus was the operation of the market. More recently, the Criminal Justice Board, as we heard earlier from Lord Patel, has set up the forensic subgroup last year to oversee the issue. In my judgment, all of these fall short of setting up the kind of thing we were recommending, namely the Forensic Science Board. And I don't know why this is. I mean, it may be that the departments have other more urgent matters of business, which I could understand, or that they need more time, or that they face the challenge of persuading some of those who are in quite deep and well-protected silos of the need for change. So the question I want to put to the Minister is this: are the interests of the judicial system and the defence community, alongside the police, adequate in establishing what we set out to achieve in this review? The second issue I would like to draw attention to is the market for forensic services, which has been described today as dysfunctional, described in evidence to us as unstable. This is not straightforward, but if we look back, I believe we can see three trends which have become apparent. One trend in provision is that in-house provision by the police has kept up increasing over the last 10 years, so that by now 80% of forensic science is conducted in-house by employees of police forces and only 20% by marketplace provision. This trend was commented on by the House of Commons report on the closure of the Forensic Science Service back in 2011, when the police had at most 40%, and the committee from the Commons made the strong recommendation that it should be prevented from increasing. Clearly, since that time, it's gone on increasing. The second trend is the charge of serious market fragility and instability. By this, I think that people mean the following: that the small number of large firms, or we have a sector here in which we have a small number of large firms which are undercapitalized. Some have withdrawn or gone into administration. Little investment seems to be made in innovation. There's a loss of skills from the profession. When the police forces join together, they act as a monopoly buyer, a monopsony, to drive down prices excessively, as Lord Mayor mentioned to us. A commoditized model for procurement, which places undue weighting on price and let on quality of service, means that we really are not getting the kind of value for money which we are looking for. And finally, that long-term contracts covering large areas will squeeze out small providers. And the third trend, I think, which has been noticeable over recent years, is the cut in budgets. You know, if you want to have a vital private sector, there have to be resources in it. And those who are purchasing have to be putting their funds into it. Whereas what we see here is great uncertainty over the structure and future investment within this business. And the question I ask myself is, if I was a private investor, which I'm not, but if I was, and I was thinking, I was in the area of science and biotechnology and so on, and I knew something about the business, would I put money into this? And the question is, there is so much uncertainty at present surrounding this market. Despite these criticisms, it's important to note that in the report, we make it very clear that we did not hear convincing arguments in favour of resurrecting the Forensic Science Service, which was closed down in 2012, and which was really a completely publicly owned or state-owned commercial organisation. What we did recommend, and I'm delighted the government has taken on board, is an expanded role for the forensic science regulator, especially in relation to the procurement process, avoiding the clustering of contracts, and maintaining capabilities of small providers. The question I'd like to ask the Minister is this: does she not feel that if we are to have a competitive market in which there is a stream of new ideas coming on and there is innovation, then the extent of in-house police provision not only needs to be halted, but actually needs to be cut back in the way that the House of Commons Select Committee was recommending 10 years ago? And I say this not from an ideological perspective. If provision by the police is more effective, so be it, let's have it. But I have a nagging suspicion that this trend will not produce the innovation which a more open marketplace would provide. And the final brief point I want to make is the importance of the defence community alongside policing and alongside the courts, and the need for there to be a symmetry in funding between prosecution and defence. This point was made powerfully by one witness, Dr. Carl Harrison, a barrister, who said that in his career he'd been commissioned by the police as the prosecuting authority 160 times, but by the Defence Counsel only by 3 times. And he concluded that this reflected the level of funding available to challenge specialist forensic evidence. It was also made powerfully in the 6 letters between the Ministry of Justice and the representatives of Keith Bora Consultants, which were provided for us by Ruth Morgan in advance of this debate. The increase in funding from 35 million to 51 million is certainly welcome. But if defence-focused organisations are to be able to recruit, train and retain high-calibre individuals, more funding will be needed. And I believe this is also an important item on the agenda of a regulator with statutory powers.
I call the next speaker Lord Krebs. Lord Krebs.
My Lords, I hope I'm unmuted.
Yes.
Although I was not a member of the Select Committee at the time of this inquiry, I now have the privilege of serving under the chairmanship of my noble friend Lord Patel, so I can say with confidence that he will have led this inquiry in a most effective and courteous way. And I thank him for his superb introduction and him and his fellow committee members for their excellent report. In my contribution, I will talk about research and development in forensic science, a theme that's been touched on by other contributors, including the noble Baroness Walmsley, my noble friend Lord Mayor, and the noble Lord Winston. The committee's report describes 3 important facets of the scientific basis of forensics: identifying the sources of a material or mark, for example, a chemical trace, the activity levels of a material, for instance, how long it might remain as a trace, and the biases in human judgment in interpreting the evidence. The report also highlights the increasing importance of digital forensics, as has already been referred to by my noble friend Lord Mayor and the noble Lord Winston. My Lords, this country has a distinguished history in forensic science. This includes the development in the 1830s by James Marsh of the Marsh test for arsenic poisoning, the use of fingerprints developed by Sir William Herschel and Francis Galton in the late 19th century, and of course, the discovery of hypervariable mini-satellite sequencers, in other words, DNA fingerprinting, by Sir Alec Jeffreys, that was first used to successfully solve a double murder case in 1986. My Lords, we also pioneered forensic science in the world of fiction. Arguably the most famous fictional detective of all time, Sherlock Holmes, was a master of forensic science and wrote several monographs on the subject. Furthermore, he was ahead of his time. He used fingerprint evidence in the story The Sign of Four, which was written 11 years before this technique was finally adopted by Scotland Yard in 1901. But moving back from fiction to fact, it may be helpful, my Lords, to anchor my comments on the need for more research on forensic science with a real example. The Royal Society and the Royal Society of Edinburgh have published an excellent set of primers on forensic science in practice, including one on forensic gait analysis, briefly alluded to by the noble Lord Winston. The question is this: can you identify a person by the way they walk, for instance, as captured on CCTV footage? Although forensic gait analysis is used in courts, the primer notes that, and I quote, the scientific evidence supporting forensic gait analysis as currently practiced is extremely limited. The report goes on to say that there is no evidence to show that gait is unique to an individual, no credible database for assessing the frequency of abnormal gait, no published estimates of the error rates of identifying individuals by gait, and no standardized methodologies for analysis of comparison of gaits. In one small published studies of the accuracy of gait identification, the failure rate among experts was a staggering 29%. In short, if gait analysis is to continue to be used in courts, more research is urgently needed. And this is just one illustrative example. In this context, it is particularly concerning to read the analysis by Professor Ruth Morgan of UCL, who, as we've heard, was the specialist advisor to the committee, that she published in 2019. She reported that over 10 years up to 2019, the research councils, now under the umbrella of UKRI, invested a paltry 5.6 million per year in forensic science, which she estimates to be about 0.1% of the total budget for the research councils over this period. Furthermore, it appears that this investment is declining from a peak of 13.5 million in 2013 to only 1.1 million in 2018. And, as Professor Morgan points out, less than half this spend is on dedicated forensic science research, as opposed to other research that might have implications for forensic science. It is also focused on short-term challenges rather than on research that would build the foundations for the next generation of new forensic techniques, so-called foundational research. But, my lords, one may well ask whether 5.6 million a year is a big or a small sum of money, bearing in mind the breadth of themes that it covers, including digital and cyber science, analytical chemistry, molecular genetics, imaging, psychology, statistics, and linguistics. Well, one way to consider whether 5.6 million is a small or a big sum of money is to put it in the context of the overall cost of crime in this country, estimated by the Home Office to be in the region of 59 billion per year. Perhaps another illustration of the relative size of 5.6 million per year in research is to note that according to a 2015 estimate, Transport for London spends roughly twice this amount each year dealing with graffiti. In short, my lords, 5.6 million seems to me to be a very small number. This small and apparently declining investment in forensic science by UKRI must also be viewed in the context of the marketisation of forensic services, already referred to by my noble friends Lord Patel and Lord Mayor and the noble Lord Griffiths of Forest Fach. According to Professor Morgan's analysis, this marketisation has had a cascade of negative consequences for forensic research. It has resulted in restrictions on dissemination of new tools because companies view their discoveries as commercial and confidential. It has resulted in a dramatic decline in the size of the market, with a reduction of over 60% in spend on forensic science services. It has resulted in a lack of investment by the private sector in research. It's against this background that the Select Committee made two recommendations relating to research and development. First, it recommended the creation of a National Institute for Forensic Science within the UKRI family, to set strategic priorities for forensic science research and development, and to coordinate and direct research funding. In its reply, the government said, and I quote, "We will carefully consider the business case for a national institute." The noble Baroness Warwick and my noble friend Lord Mayor interpreted this as a polite form of rejection of the idea. The committee also recommended that, and I quote, "Current levels of investment in forensic science research are inadequate and do not appear to reflect value to the criminal justice system. We believe that the Home Office has abdicated its responsibility for research in forensic science. We recommend that UKRI urgently and substantially increase the amount of dedicated funding allocated to forensic science for both technological advances and foundational research, with particular focus on digital forensic science evidence and the opportunities to develop further capabilities in AI and machine learning. In its reply to this recommendation, the government said that it will ensure that policing and the criminal justice system benefit from advances in science and technology by developing and implementing new forensic techniques more coherently. It added that the Home Office and MOJ are focused on developing an even stronger working relationships with UKRI and working with them and other strategic partners to develop and set strategic priorities for forensic science research and development. The government's response, however, makes no reference either to foundational research or to evaluative interpretation. I therefore, in closing, ask the Noble Baroness the Minister to update us on her response to these two recommendations. Has the government concluded its careful consideration of the case for a National Institute for Forensic Science? And if so, what did it decide? Has there been an increase in the amount of public funding of forensic science research? And has this included more funding for foundational research as recommended by the Select Committee in its excellent report?
Baroness Joles of Moulscombe.
I'd like to begin by thanking the Science and Technology Committee for their work in producing this excellent report, and its chair, the Noble Lord Patel, for his masterly exposition of what the report is all about, and of course the committee staff who've been so incredibly helpful in briefing peers ahead of this debate. I am now going to exhibit my worst character defect, according to some of my friends. And I will say that I was not a member of the Science and Technology Committee, but I was a member of the Metropolitan Police Authority for the 12 years of its existence from 2000 onwards. And as soon as this idea was floated, that of privatising the national service for forensic science, I actually made a speech in which I said, this is a mistake and it's going to cause all sorts of problems. Well, I told you so, or rather I told them so. And I was very unhappy when it finally went ahead. The worrying thing that underpins all of this from across the forensic sector, the committee and the government, is the acceptance that miscarriages of justice have occurred as a result of these failures and changes and inconsistencies in the way that forensic science is conducted. So the fact that some people may have been found guilty and guilty people may have been found innocent should worry everyone in this country, because it undermines the whole justice system and the rule of law. I'm yet to see any serious reflection from the government on the implications of this fact, or any attempt to ensure that these injustices are remedied. And this is an issue I will come back to, and that is, I'd like the Minister to explain what conversations the government has had with the Attorney General and the Lord Chancellor to trawl through these past cases and ensure that any forensic errors are put right, and that anyone wrongly convicted has that conviction overturned. This work should be conducted using government funds and not be constrained by the availability of either individuals' funds or legal aid. Turning to legal aid specifically, the government's response to the report sadly expresses that they are not aware of legally aided defendants being denied access to testing and expert advice for funding reasons. I'd like to ask the Minister to expand on what basis they make that assertion. Is it founded in ignorance, or have they actually gone out of their way to seek examples of legal aid limits getting in the way of justice? I ask this because some peers had an email from a forensics organisation who does mostly legal aid criminal defence work. They say that while the three main laboratories who work with the police have had significant increases in funding recently, there has not been a corresponding increase in funding for the defence. And they say that they have tried to engage with the government about the legal aid funding to no avail. For example, on the arbitrary limits on to travel time of 4 hours. Now, this doesn't tally with the government's claim that people are being denied access to forensic science they need to prove their innocence. To conclude, I believe it's impossible to separate this issue of forensic science from the wider undermining of criminal justice funding that's occurred during 11 years of Conservative cuts. The noble Lord, Lord Patel, said at the beginning, in the evidence, somebody said that it was national crises that had brought us to this point. But actually, of course, it wasn't. It was political decisions by the Conservative government that actually made it clear that we would do this and go this route. So the government has actually treated people's innocence as a sort of unaffordable and optional luxury, rather than the underpinnings of the very fabric of society's trust in the justice system. Because when people realise that innocent people can go to jail and guilty people can go free because of the failures in the system that the government has allowed to happen, then the whole system is doomed.
My Lords, Lord Morris of Aberfan has withdrawn, and from the list of speakers, I now call Lord Thomas of Kingaid for the debate in this group.
My Lords, it was a great privilege to have been co-opted to this committee for this inquiry, and a privilege, a pleasure, and indeed an education to have served under the wise and far-sighted leadership of Lord Patel. It was sad during the course of the evidence to hear of the decline of the respect in which the leadership that the UK had shown in forensic science had declined so rapidly. Only a few years before, that leadership had been celebrated at a conference organised by the Royal Society, which demonstrated that the UK was then significantly ahead of several states and ahead of the leaders in the field, which are acknowledged to be Australia, Switzerland, the Netherlands, and the United States. I had hoped that this report would provide the opportunity for the UK to regain that lead, particularly as a result of serious issues relating to forensic science that had arisen in the United States under the leadership of its then president. The report concluded that the failings in the system were due to three matters: lack of high-level leadership, lack of funding, and insufficient research and development. Lord Patel has given a perfect overview, and I would like to join with him in the tributes to those who advised the committee. Other noble lords have dealt with other issues, and in particular the market, AI, and miscarriages of justice. I would like to confine my remarks to leadership, to research and development. I appreciate the focus of the criminal justice system over the last year and a half has been in dealing with the problems brought about by COVID-19. But forensic science is essential to justice, and nothing can really excuse a failure to plan ahead now to restore the position. Can I first, therefore, turn to the need for high-level leadership? I tried to find out what has happened since the government's response to the report in July of 2019. The Criminal Justice Board publishes its minutes, and the minutes of July 2020, which were the last I was able to find, said this. They're short, so I can quote them. Forensic Stocktake 2020. The Lord Chancellor spoke about the importance of forensics within the CJS and was pleased to receive an upgrade from the forensic subgroup to the CJB, which is jointly chaired by the Ministry of Justice and Home Office. Baroness Williams of Trafford noted that the subgroup had identified the need for the forensic science regulator to become a statutory body. The Lord Chancellor thanked the subgroup for all their work and invited the members to provide further comments out of the meeting on the paper presented. Well, I'm afraid that, if I may with respect say so, is not very informative as to progress over a year. But more seriously, the Criminal Justice Board has much else to do. In the years I served on it or went to its meetings, which were shortly after its formation until I retired as Lord Chief Justice, it was not the kind of body, nor was any subgroup the kind of body, that was effective at the detailed issues which require great expertise and knowledge of science and the law with which this issue is concerned. However, more serious is the problem that its work on forensic science needs to be independent and accountable. The minutes show how unaccountable it is because there's no explanation of what it does, and it cannot be regarded as independent. The forensic science needs to serve the police, the prosecution, the defense, and the interests of justice. So it's very difficult to see on that first issue what the Criminal Justice Board subgroup has done. The second thing that has happened is putting the Office of the Forensic Science Regulator on a statutory basis, or about to be on a statutory basis. Dr. Gillian Tully was an excellent regulator. She retired 2 months ago. She was a pleasure to work with, achieved a great deal, and her most recent achievement was dealing with the very difficult subject of standards for evaluative opinions, which play such a large role in the evaluation of forensic evidence. There's an interim regulator, but when is the new regulator to be appointed? And when is the government going to look seriously at its powers? Because that is the key issue. Because although the regulator's role is key, it is not that of leadership. It is to ensure quality and accreditation and to ensure the market functions efficiently. It is not independent, and it cannot provide the leadership of scientific research and the holistic leadership that is required in our system. I look forward to hearing that much more may have been done, but I could not find it. Maybe that is due to my inability to trawl the records with sufficient detail, but I could find no explanation elsewhere. I very much look forward to what the noble lady and Baroness the Minister is able to say about progress. The UK needs to be back at the top of the league, and it can only do that with a holistic leadership set out in the report. The second aspect I want briefly to refer to is the need for proper funding of independent forensic research. And again, can I refer to just two areas, digital and DNA? It is clear from the evidence received by the committee and evidence I received when chairing the Welsh Government's Committee on Justice in Wales that digital forensic remains a major issue. Indeed, it has been an issue for the last 9 years. What has happened is that the two things have gone hand in hand. The increased power of mobile devices and their ability to store so much, and which comes as a surprise to many, they increase use of them for communication in permanent records of things that would never, ever have been recorded before. They are therefore essential to the administration of justice, not only to establishing guilt, but also to showing that conduct that may be complained of was innocent. The use of digital forensics is important to the deterrence of crime through successful prosecution, the confidence of victims in the system, as assurances about the way information contained in phones is critical, and equally important to the proper use of police time. For example, in commercial litigation, increasingly sophisticated and independently reliable software has made a very significant difference. It extracts and it searches properly and reliably. As far as I can ascertain, there are still serious issues of what needs to be done to tackle these matters, extraction and particular searching, so that something reliable is available to the police, the prosecution, and the defense, so critical to the three issues to which I've referred. There are other aspects, such as AI and facial recognition and deep fake, about which Lord Mayor has spoken, which underlines the urgent need to address an area which needs significant leadership and investment. DNA has been essential to the criminal justice system since the 1990s. It has made a significant contribution to the conviction of the guilty, but also, equally importantly, to the exoneration of the innocent. It's been a journey that has not been without its problems. Low template DNA brought about serious miscarriages of justice in the way in which it was first used. And mixed and partial profiles and transfers have again been a real problem. Much has been done, and the Royal Society has led with a primer of this subject, parallel to the one about which spoken of a short while ago. But there are issues, as I understand it, with mixed and partial profiles and transfers, and much more needs to be done. But these are but two examples of the need for development and research, and it's development and research that is both scientifically independent and not dependent on police budgets. The forensic science budget, to the extent that it is now largely in the hands of the police, must be looked at again. I very much hope, as Lord Krebs has already stated, that the Minister is able to tell us a bit more about what UKRI has been doing, what advice it is taking, and what it is going to do to bring investment to these vital areas. But let me just look at a way forward. I hope that way forward will be by government action. In March 2011, the Law Commission produced an excellent report on expert evidence and draft legislation. 2 years later, the government said it wouldn't bring forward the bill and made clear, therefore, something, it was up to others. Leave the law as it is or look for change. What happened then was that all the reforms envisaged by the Law Commission were brought about by the criminal procedure rules, much to the benefit of the criminal justice system, and it worked. The report we have been speaking of is the 10th in 10 years. Nothing much, as far as I've been able to ascertain, has happened, though I hope the Noble Baroness, the Minister, will be able to tell us otherwise. It may be that it is because structures are not devised to be accountable or informative. However, forensic science is essential to justice, as the speech of each of your lordships has shown, and it is also essential to keep the UK in the forefront of world leadership in science and the law. I trust that Her Majesty's government will not fail in restoring the position, but if not, I hope we will be able to find an example similar to that which was taken in relation to the report of the Law Commission and find another way to put into operation this excellent report if Her Majesty's government feels it is unwilling or unable to do so.
I call the next speaker Lord Fox.
My Lords, I often start speeches by saying it's an honour to follow this Lord or that Lord, but I have to say absolutely it's a great honour to have followed such expertise and speeches that we've heard already, led off, I would say, by Lord Patel's outstanding speech, which counterpoint to his outstanding leadership of the committee in this report. My Lords, we're here today to celebrate the second birthday of this report. It was published in April 2019, when I was a member of that committee, the Science and Technology Committee. The government responded in July of that year, 2019. Since the summer of 2019, it's safe to say some water has passed under the bridge. And the first of that was, of course, the general election in 2019, and then, of course, COVID. The general election means that, in fact, it's a different Conservative government to the one that made the initial response, although I note the Minister has remained the same. So I'm assuming that the Minister stands by that response that was made by this different Conservative government, and we're not, as in other cases, dealing with a distancing. When it comes to the pandemic, the criminal justice system has, like all aspects of public life, come under extreme pressure. So the backdrop for discussing this could hardly be more difficult. And that's not only because of the virus. The Lords Constitution Committee set out issues last month. The pandemic, it said, has left the courts system in England and Wales in crisis, with a backlog of cases that will take years to clear. Importantly, it also said a decade of cuts has meant that the court system was already in a vulnerable state when the disease outbreak occurred last year. It went on, without adequate resources, technology or guidance, our much cherished justice system remains at risk. My Lords, that report very much reinforces the situation that we're here discussing today about the Forensic Science Service. And I hope that COVID isn't used as an excuse for where we are now. In its response, the government, to the report, the government was clear. The government, it said, agrees that the delivery of justice depends on the accuracy of evidence. It also said, that's the government's top priority is to prevent miscarriages of justice. These are both very reassuring comments. But of course, without willing the means, they're quite flimsy. So we should ask the Minister whether she thinks that the government is doing everything possible to ensure that evidence is as accurate as possible. And is it doing all it can to avoid miscarriages of justice? If the noble Baroness Williams is frank, as she usually is, I'm sure she will be able to indicate that there's work to be done, and it would be important to indicate what the timeline for that work is. Because, my Lords, not to put too fine a point on it, other Lords have mentioned it, justice often, and more often than not, hinges on forensic evidence. If the evidence is inaccurate or it is inadequate, then justice is compromised. And as many of your Lordships have said, once confidence in the evidence goes, then the confidence in the whole justice system is compromised, and that is central to our democracy. Now, I hasten to add that thanks to the dedication and hard work of many practitioners, that terrible situation is largely avoided. But I ask the Minister, what about the environment these people work in? Does it have the finance it needs? Does it have leadership? Does it have a structured approach to standards? Is it doing the necessary work to embrace the future? And is there equal access to necessary services? Now, many of these have been covered by your Lordships, and I apologise for some repetition, but I'm going to take them each in turn. There will be many questions, there already have been. I hope the Minister will undertake not just to answer as many as possible in her verbal response, but in writing and publish that in the library. And she's nodded, and that's very helpful. So first off, does the Forensic Science Service have the finance it needs? Well, we've heard what the Constitution Committee has said about the whole justice system, and Forensic Service, of course, has not escaped. As Lord Mayor enumerated, in 2010, some 120 million was spent on forensic science. In 2019, this had dropped to 50 to 55 million. So could the Minister tell your Lordships what the budget for this and next year is? In the government response to the issue of market stability, the role of a special team set up by the National Police Chiefs Council within the Forensics Capability Network was highlighted. This team, it said, is going to cooperate across police forces and, quote, manage commercial strategy, manage contracts, coordinate capability building, and provide long-range demand forecast. My Lord, the noble Lord Griffiths, sitting opposite me, knows more about markets than most people, and I think his critique of this situation is one that I hope the Minister will study carefully. I had written down the words, this is a good way of creating a more effective monopsony, and that is exactly what is happening. It does not help the structure of the service providers one iota. But that said, what actually has this body done? How many police forces are now bought into the network, and by exclusion, how many are not bought into this network? And what concrete initiatives have we seen over the past 2 years on the subject of market and market structure? How does the government actually assess the stability of the market, or indeed who does it rely on to make that assessment for it? And of course, some private sector companies, as we heard from Lord Winston, have adapted their services for COVID-based services, but I think we need to study this on pure forensic service terms. The government also committed to provide all budget holders with data and measures to assess the impact of forensic spend on outcomes in criminal justice system. Now, I find this a very intriguing sentence. So what outcomes is it targeting? Is it pounds per conviction? Or what? So what data, what measures is the government providing to data holders? And when will those measures and that data be published? Turning to the next issue, which is around the leadership of forensics. We've heard categorically from many speakers how our proposal for the creation of a Forensic Science Board was designed to create strategic focus. I'm not surprised that Her Majesty's government has damned the idea with faint praise, or actually with no praise at all. On the other hand, what it offers is an alphabet soup. The MOJ, the Home Office, the National Police Chief Councils, Forensic Capability Network, College of Policing, Criminal Justice Boards, UCAS, the Chartered Society of Forensic Science, UKRI, the Forensic Sciences Regulator, and of course all the companies in the private sector providing the service. And I'm sure I've missed some out. So, Minister, I have one simple question. In the regrettable instance of a miscarriage of justice due to a problem with the forensic evidence, where does the accountability lie? With whom does the buck stop? Third point, does forensics have a structured approach to standards? In this, my lords, I'm uncharacteristically optimistic, or I've been led to be optimistic by the Earl Lindsay, who set out the work that the regulator is doing with UCAS. But as other lords have said, that regulator needs the powers and it needs the resources. And I think it would be helpful if the Minister could say, where are those resources going to come from? Because if they come from a levy, it will be levying an already impoverished sector. Is Forensic Service doing the necessary work to embrace the future? This is a debate unto itself, and we've heard phenomenal contributions from some of your lordships. The government's response raises the prospect of a document the Forensic Capability Network is creating, a 5-year roadmap to prioritise rapid development in key areas such as DNA and digital innovation. Now, I looked for this document and I couldn't find it. So does it exist? And if it doesn't, can the Minister confirm which 5 years it's covering? If it does, can the Minister explain where we might find it? And finally, is there equal access to the necessary services? This is perhaps, I think, the most vital single issue, because without equal access, we do not have equal access to justice. Without justice, we do not have democracy. The report set out the issue of access to forensics for defendants, particularly those on legal aid. As we've heard, the government said it's not aware of legally aided defendants being denied access to forensic testing and expert advice for funding reasons. I think that flies in the face of the evidence we heard, my lords, and the chairman of this committee, Lord Patel, set out a clear case as to why the government should be concerned about this. But looking elsewhere, and the Noble Lord Griffiths talked about asymmetry in the market, there is a very, very important asymmetry that we have not talked about yet in detail. And it's around the availability of service. And here I cite none other than the website of the Forensic Science Network itself. Okay. So if you go to the homepage of that Forensic Science Network, and we'll remind ourselves how important this is to the government in a minute, it says, "Welcome to the new network for forensic science in England and Wales, supporting more than 4,000 specialists with critical services, advice and technology," it says. So far, so good. Next line, we come to the strap line. FCN is the UK's largest forensic science network for policing, by policing. For policing, by policing. Watch those words. And it reinforces this elsewhere if you dive in to some of its purpose. It, the FCN, provides much of the evidence that can identify and bring offenders to justice. My lords, it characterises forensics in that way. I and the rest of the committee characterise forensics as bringing justice to a court proceeding. That is not the line that the FCN takes. So let's remind ourselves, this is the FCN that is tasked to set out strategies, we've heard earlier. And this is the FCN that is managing the market for forensics. Lord Thomas spoke about the need for independence. This is in no shape or form independence. Now, an independent forensic service is one way of going about gaining that independence. This report goes another way and talks about having a structure that delivers independence. So, my lords, I conclude that this service has not delivered, and it's not just because of financial starvation. Structurally, there is a big problem in the middle of the way this service is delivered, and the government should very carefully look at this debate and look at this report.
I now call the next speaker, Lord Rosser, and at the same time turn over the chairmanship to Baroness Watkins.
First of all, I too would like to congratulate the Noble Lord Patel and his committee for their report, which is very clear in its message, in its findings, and in its recommendations. Just over a month ago, we had the second reading debate on the Forensic Science Regulator Bill. And during that debate, the Noble Lord Patel referred to the Science and Technology Committee as its chairman and their report, which we are now discussing. The Noble Lord said that the Regulator Bill, which he supported and welcomed, was nevertheless a missed opportunity for the government to address other issues in relation to forensic science and its use in the criminal justice system, since the quality and delivery of forensic science in England and Wales are, quote, inadequate, close quote, a statement the Noble Lord Patel has repeated today. What were those other issues, and why is the quality and delivery of forensic science in England and Wales inadequate? During the debate last month, the Noble Lord Patel asked what role the Home Office and the Ministry of Justice would play in the governance of the Forensic Science Service, as currently there was, he said, a lack of leadership. There was, too, the Noble Lord said, an increasingly dysfunctional forensic science market. The quality of forensic science needed bolstering, and research and development in forensic science was under-resourced and lacked coordination. The Noble Lord Patel said that the United Kingdom used to be regarded as the world leader in forensic science technologies and innovation, but that we are now regarded as a place where not to look, including in digital forensics, where the demand for digital evidence and the complexity of the requirements continues to grow. And today, the Noble Lord Patel has also referred to the impact of budget cuts, of reorganisations, of cuts to legal aid, and exponential growth. And in that same debate on the second reading of the Regulator Bill, my noble friend Baroness Young of Old Scone, who was also a member of the Science and Technology Committee, referred to the instability of larger providers, the patchiness in availability of specialists and niche providers, and the lack of a strategic overview of future skills and staff requirements. All pretty damning observations, many if not all of which have been repeated in the contributions today. In their response to the debate last month, the government said that the decision to close the Forensic Science Service in 2012 was because it was losing an estimated £2 million a month. As with the ill-fated probation service reorganisation, it looks as though scant regard was paid by the government to the effectiveness, stability, and suitability of the alternative arrangements that were introduced, hence why we're in the position we are in today with inadequate forensic science provision in the criminal justice system. And I quote the last paragraph of the summary of the committee's report. Quote, unless these failings are recognised and changes made, public trust in forensic science evidence will continue to be lost, and confidence in the justice system will be threatened. Crimes may go unsolved and the number of miscarriages of justice may increase. Furthermore, world-leading specialist expertise will be underused, and England and Wales may never regain its reputation as holding the international benchmark for forensic science. This report follows others that have raised similar concerns, yet the changes that are necessary have not been made, despite acknowledgements that they would be. Forensic science in England and Wales is in trouble. To ensure the delivery of justice, the time for action is now. Yet there seems to be no shortage of bodies, organisations and programmes with an involvement as far as forensic science services are concerned, a point that the Noble Lord Fox drew attention to. And possibly that's also part of the problem. The government's July 2019 9-page response to the report refers to the Forensic Science Regulator, UK Research and Innovation, UKRI, Home Office Science, Forensic Policy Steering Group, the Criminal Justice Board, the Home Office, the Ministry of Justice, the Forensic Science Strategy, the National Police Chiefs Council, the Forensic Capability Network, Police and Crime Commissioners, the Legal Aid Agency, local criminal justice boards, the United Kingdom Accreditation Service, UCAS, the Chartered Society of Forensic Sciences, the Regulators Advisory Council, the Royal Society, the Transforming Forensic Programme, the Criminal Procedure Rule Committee, the Digital Investigation and Intelligence Programme, and the College of Policing, in addition to police forces, providers, and criminal justice system stakeholders. The Science and Technology Committee report we're discussing today refers to the problems highlighted by Noble Lords both today and during the second reading debate on the Forensic Science Regulator Bill last month. However, as has been said, the report was published exactly 2 years ago this coming Saturday. The government's response to the committee's report was published in July 2019, 1¾ years ago. I may be in a minority, but I do not see how the role and effectiveness of this House is enhanced by that kind of delay in discussing one of our own committee's reports. The only benefit the lengthy delay does have is that it makes it more difficult for the government credibly to simply tell us what they intend to do in response to the report, as opposed to what they actually have or have not done, and what specific improvements have already actually been delivered over the last 1¾ years since they published their response. So I will be looking for the government to spell out what specific improvements there have actually been in the provision and delivery of forensic science in the light of the recommendations made and problem areas identified by the committee in their report beyond the completion of the passage of the Forensic Science Regulator Bill. During the debate last month, the government referred to presentation of plans to the Criminal Justice Board, setting out 4 key pillars of a forensic science reform programme, work being progressed with the Ministry of Justice, the Regulator's Office, and other stakeholders, investing £28.6 million to accelerate innovation and combat crime, provide police forces with specialist support functions, publishing a digital forensic science strategy, developing a workforce strategy, and supporting the Forensic Science Regulator Bill, something the government had said they would do 5 years ago. The impression I get from that government response last month is that over the last 2 years, there have been no actual specific improvements to the inadequate quality and delivery of forensic science in the criminal justice system as identified and spelt out in the Science and Technology Committee's report. Now, if I'm wrong in saying that, then could the government either in their response today or subsequently in writing spell out what those measurable specific improvements in the quality and delivery of forensic science have been over the last 2 years, which have addressed issues identified by the committee in their report. If I'm basically right in saying what I did, then could the government, either in their response today or subsequently in writing, spell out what measurable, specific improvements to the inadequate quality and delivery of forensic science in the criminal justice system, as identified and spelt out in the Science and Technologies Committee's report, they are now committed to introducing, implementing and achieving, and within what specific timescale? Too much of the government's written response in July 2019 and to the debate last month seemed to be about changing the way things are done rather than a commitment to delivering specific and clearly identifiable and measurable improvements in the quality and delivery of forensic science in England and Wales, which the committee in their report said was inadequate. And in their response in July 2019, the government said this in their conclusion. It's paragraph 24, and I'll read it out. They said, through implementation of the Joint Review of Forensic Science and its ongoing consideration of their Lordships' recommendations, the government expects the provision of forensic science into the criminal justice system to be significantly strengthened. The Home Office and the Ministry of Justice are jointly responsible for bringing about the collaboration, investment, and oversight required to make this happen, close quote. If the government are confident that what they intend to do will deliver specific and clearly identifiable and measurable improvements in the quality and delivery of forensic science services, then they should set out what those improvements will be, how they will be measured, and within what timescale. It's called being accountable. If the government cannot do that, how can we or they judge in the future whether the government's response to the issues the Science and Technology Committee has said need addressing has actually delivered or not? Like other noble lords, I await the government's response, including the extent to which they do or do not intend to implement the recommendations in the committee's report.
I call the Minister, Baroness Williams of Trafford.
My Lords, may I start by thanking the Noble Lord Patel for securing this very vital debate. Could I also thank the Science and Technology Committee for their very thorough inquiry into forensic science and its subsequent report. My Lords, if I could, I'll go through the tenets of the report and the questions arising out of it today. The report was very clear, and my noble friend, the Earl of Lindsey, spoke enthusiastically about this, that the Home Office and the Ministry of Justice needed to provide joint leadership in forensic science, and that the governance needs to inspire effective collaboration and cooperation across operationally independent bodies. And as a direct result of your Lordship's report, we did create a steering group jointly chaired by the Home Office and the Ministry of Justice. It soon became an official subgroup of the Criminal Justice Board, reporting to the Home Secretary, the Justice Secretary and the Attorney General. The subgroup is delivering a vital reform programme, which I will come to later. But this spirit of cooperation has strengthened over the last 2 years. Their work is ongoing and it meets every 6 weeks. My Lords, to reiterate, this government is committed to protecting the public and keeping our streets safe. Scientifically robust evidence is one of policing's most important tools for investigating crime. The successful prosecution of county lines drugs gangs, sexual offences and violent crimes is often dependent on high quality forensics, including digital forensics and DNA analysis. And I think we should always remember the Stephen Lawrence case, it was only because British scientists were able to detect and analyse a drop of blood measuring less than 1 millimetre in diameter that his family were finally able to achieve some measure of justice. And my lords, despite everything that has been said this afternoon, this country does have some of the world's best forensic scientists, both in public law enforcement and within the private sector, and every day their expertise is deployed to solve crime and to deliver justice. And the Noble Lord Thomas of Cumgead and the Noble Lord Rosser talked about comparators with other countries and in particularly across Europe. When compared to 9 other European networks of forensic science institutes, state labs across Europe, turnaround time in England and Wales using comparable metrics are world leading. In terms of drugs casework, England and Wales turn around in 21 days, elsewhere it's 24 days. DNA casework, England and Wales, it's 10 days, elsewhere 43 days. So, my lords, I think we should commend really our forensic scientists here in the UK and their ability to turn things round. And, my lords, I also welcome the significant efforts made by those involved in this work to markedly improve turnaround times. But forensic science, as Noble Lords have pointed out, has faced challenges in recent years, including constrained resources, as I think all Noble Lords have said, and a growth, of course, an exponential growth in the volume of new sources of evidence, such as digital material. We have taken steps to address this, to answer the question of the Noble Lord Krebs and others, investing over 28 million in 2021 in the Transforming Forensics programmes and a further 25.6 million in 21-22 to continue to strengthen forensic services for policing, including digital forensics that the Noble Lord Mayor spoke about. My lords, we helped to set up the police-led forensics capability network, and our investment in it is bringing some much-needed stability to the commercial market. When it comes to quality, the former forensic science regulator worked closely with all partners to establish standards for the collection, analysis and presentation of evidence. And these are established in the regulator's code of practice. Adherence to these codes, whether they're employed by police forces or privately contracted, plays a key role in ensuring that the evidence used in investigations and presented to court can be relied on, something that Noble Lords have underlined this afternoon. What the former regulator rightly highlighted in her most recent and final annual report, as well as in discussion with my department, was the inability to enforce those standards and how that's resulted in slower progress towards compliance with quality standards across the forensic community. I agree. That is why we fully supported legislation to give the regulator the power to enforce quality standards as a last resort and to take out action where they have reason to believe that substandard forensic science activities are creating a substantial risk to the course of justice. And the Noble Lord Winston talked about the Randox case. Obviously, it's subject to an investigation at the moment, so I won't talk about it. But that legislation that we supported, my lords, is a very specific improvement that I know the Noble Lord Rosser and the committee will agree with. But I know that there are Noble Lords who think that, and others that think that legislation didn't go far enough. My lords, we don't claim that giving the regulator these important statutory powers will on their own be enough to address all the issues currently facing the provision of forensic science, not at all. But what it does represent is a significant milestone in the delivery of quality forensic services in England and Wales. And I would like to thank the Noble Lord, Lord Kennedy of Southwark, for successfully stewarding the bill through the House. And of course, there is more to do to go to the Noble Lord, Lord Fox's point, and that is why we are working with the Ministry of Justice, the Office of the Forensic Science Regulator, Policing, the Attorney General's Office, and other key stakeholders to deliver our Forensic Science Reform Programme. This programme was agreed by the Criminal Justice Board in July of last year. It will make good on the commitments set out in the Joint Review of Forensics Implementation Plan published in 2019, and it will go some way to tackling the issues identified in the committee's excellent report. The reform programme is organised around 4 pillars to deliver strategic oversight and leadership across the criminal justice system for the future of forensics. The first is police capabilities. In 2021-22, we are providing 25.6 million in funding to the police-led Transforming Forensics programme, as I've said, so that they can continue to build the forensic capability network to provide specialist support functions to forces such as increased capacity in digital forensics, particularly in child sexual exploitation investigations. The second is regulation of provision, and I've already spoken about the Forensic Science Regulator Bill. We're also providing a clear legal framework for the extraction of information from digital devices belonging to victims and witnesses through the Police Crime Sentencing and Courts Bill. We will provide guidance on the use of this power through a statutory code of practice. We'll also consider the legal framework for suspects through the response to the Law Commission report on search warrants. The third pillar is criminal justice system capabilities. MOJ is working to increase transparency of expert witness credentials and ensure that defendants have equal access to experts. The CPS and the Judicial Office, together with other key stakeholders through their membership of the Forensic Subgroup, are helping to oversee and deliver on this important strand, to answer my noble friend Lord Griffiths' question. And the fourth is research and development. My Lords, the Home Office Science and the Forensic Capability Network are working together to identify current and future research needs and design and implement a research and development model to meet the needs of the sector. Home Office Science has developed strategic mapping of potential funding routes for forensic science research and development, and in addition, the Forensics Capability Network has developed working groups across the sector to inform the research strategy and development of capability roadmaps for forensic disciplines. Taken with the legislation to give the Forensic Science Regulator statutory powers, this reform programme, we think, represents a joined up and concerted effort to address the issues facing forensic science in England and Wales. My Lords, that is basically the tenets of the report. But in terms of specific questions, and if I don't get to any of the questions that Noble Lords asked, because actually there were quite a lot of very sensible questions, I will follow up in writing, as I usually do. The Noble Lady Walmsley talked about training, and I agree, but of course the police are operationally independent, and we can't dictate as a government, but what the statutory regulator can do is investigate labs, including police labs, which the Noble Lord Winston mentioned, that fall short of standards. And the Earl of, my noble friend the Earl of Lindsay, asked about the accreditation of services. It's tied up with powers for the regulator by having statutory investigatory powers, should be able to take action against providers who fail to accreditation. And the Noble Lord Mayor are asked about procurement model. My Lords, the forensic subgroup has representation from the Association of Forensic Science Providers and Policing Forensics Capabilities Networks commercial arm, so that market issues and procurement are discussed. In terms of my noble friend Lord Griffiths' question about police provision, again, they're operationally independent. It is for them and the PCCs to decide what is best, and they are best determined what is needed. Noble Lord Krebs asked about the National Institute. I will, if he is okay with that, to provide a more fulsome response to that. Noble Lord Fox made absolutely the right point about evidence being as accurate as possible. We don't have an effective criminal justice system if it is not. And I think that giving the regulator statutory powers will drive up quality standards and help ensure accuracy of evidence. MOJ are leading on work to ensure forensic science is properly presented in court. On the budget, we will work closely with the regulator's office to ensure that they get the resources they need. And on the market, we do assess the stability of this via the subgroup, and the Home Office and the MOJ are accountable. I will write some of the other points that he has made as well. The Noble Lady Warwick of Undercliff and Noble Lord Rosser alluded to the Forensic Science Service, which closed in 2012. They did point out, of course, because it was losing £2 million a month of taxpayers' money. And while that isn't a reason for its closure, there were repeated failings in addition, which led to multiple case reviews and retesting programmes. And the move has brought benefits. Commercial provision has had a significant positive impact on the delivery of forensic science, including increased resilience, faster turnaround times and reduced costs. As I did read the report thoroughly, and I noted that the committee did recognise that a return to the FSS was not a desirable way forward, as my noble friend Lord Griffiths pointed out. And I do think that we are more joined up than we were back in 2019. Noble Lord Patel and Rosser referred to budgets continuing to be under pressure, and yet the demand for digital evidence and the complexity of its requirements continue to grow. And Noble Lord Rosser referenced the Noble Lady Young talking about this in the Forensic Science Regulator Bill's second reading of last month. My Lords, our Forensic Science Reform Programme recognises that the demand for digital evidence and the complexity of its requirements continue to grow, and that is why I am pleased that the MPCC published its digital forensic science strategy last summer, and that we invested over 28 million in 2021 in the Transforming Forensics Programme, and a further 25.6 to come. Noble Lord Patel talked about the cost to defendants of getting a second opinion on forensic evidence is more expensive than the legal aid budget is, meaning that there's a potential for unsafe convictions as evidence cannot be effectively challenged in court. My Lord's, legal aid regulations prescribe the maximum rates that are payable to forensic scientists and other experts, but these rates can be exceeded in exceptional circumstances. and the Ministry of Justice is currently working to increase transparency of expert witness credentials and ensure that defendants have an equal access to experts. Noble Lord Patel and I think someone else on the committee talked about the regulator working 3.75 days a week. My Lords, the regulator is currently defined as a part-time role, but what we do recognise is that the regulator will have a higher workload as a result of the legislation, and there will be additional recruitment to the regulator's office to meet this need. I think it was the noble lady, Lady Walmsley, who raised concerns about unqualified individuals being able to pass themselves off as experts in court when their credentials may be in doubt. I agree with her concerns, and the powers contained in the Forensic Science Regulator Bill will enable the regulator to publish lists of those unsuitable to be instructed as experts. I think, my Lords, I have probably covered everything. Oh, final question from the Noble Lord Patel. Where in the government does the accountability lie for provision of quality of forensic services to assist the justice system? My Lords, it's a joint effort by the Home Office and the Ministry of Justice, but to finish on the questions on Noble Lord Fox, who does the buck ultimately stop with? My Lords, it stops with the Home Office. A straight answer to a straight question. Before I finish, could I just thank, and I know members of the committee have also said this, thank Gillian Tully for the excellent work and the dedication that she gave to the role. I hope that her replacement will be just as good as she was in performing that role. So thank you to the committee, and I will follow up any questions in writing.
I call Lord Patel. Lord Patel, please could you unmute?
Yes, I have. I'm sorry. Thank you for reminding me, Lady Watkins. My Lords, I thank Noble Baroness, the Minister, for her comprehensive response. I also thank all the Noble Lord for her, what I thought was a very thoughtful, measured, excellent contributions. It, in my view, is one of the best debates that I've heard and have taken part of in recent days in the House. In response, it's not my nature to be confrontational. I'm not going to be confrontational. But much of the response, and I think the way the Minister formed her response, shows that much of the work is in progress. But she does suggest in her response that the government is taking note of some of our recommendations and finding a way to take them forward. And I hope that is correct, because I think I have no doubt she's heard all the contributions today, which not only were powerful, but well-meaning and supportive. I think there is a recognition that the Forensic Science Service, the way it serves criminal justice system, needs to be looked at. And if that's the message I'm getting from the Noble Baroness's view today, then I am satisfied. Of course, it does give the Science Technology Committee an opportunity, especially as the report is now 2 years old, to revisit the whole thing, maybe in about 18 months, in a short follow-up report, and we may well do that. But for today, I thank the Noble Baroness, the Minister, and I also thank all the Noble Lords who took part today in what has been an excellent debate. So I thank you.
The question is that this motion be agreed to. As many are as of that opinion shall say content. The contrary not contents. The contents have it. That completes the business before the Grand Committee this afternoon. I remind members to sanitise their desks and chairs before leaving the room. The committee is adjourned.
The proceeding has ended. 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 The proceeding has ended.